to order. Today's meeting of the Municipal Code Enforcement Board is called to order on January 28th, 2026. Welcome, everyone. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes, and the board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to rise and be sworn in by our clerk.
Do you swear to affirm to tell the truth throughout your entire testimony? I do. Thank you.
Our first order of business is going to be to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
Motion to approve.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion approved. Next on the agenda is our new business items. We're going to start out of order today. We're going to call agenda item 3.28, continued from December 17th, case 197-25, fire and respondents Moss and Associates at 400 Coronado Avenue in violation of code for illicit discharge, and issue an order with compliance deadline and fine if not met. Is there anyone here to speak on that? Counselor?
Thank you, Mr. Chair. Jared Simpson with the City Attorney's Office. As you know, we continued this case last month as we were discussing a resolution with the respondent here. We do have a stipulated order that we're asking for the board to approve. Just to give you a quick rundown of that, they are accepting responsibility for the situation. The order would find that a violation did occur, and it imposes a fine in the amount of $42,500. This is a stipulated order that the parties have agreed to. If you have more questions about it, the staff's here to answer that, but we're asking that you approve this. This is something that both the parties have agreed as a fair resolution to this situation.
Okay. Board, do you have any questions for Counselor Simpson? No? We would put this under just a regular motion.
We asked the motion to be just to approve the stipulated order as presented.
Okay, would we have to find them in violation first? Is it first motion? No?
No,
Okay.
just adopt the stipulated
Okay.
order.
Can I get a motion to find them in violation?
I move to accept the stipulated order as presented in case number 197-25.
Have a second?
Second.
All in favor?
Aye.
All opposed? All right, motion carries.
Thank you.
All right, now back to our order here. 3.1 on our agenda has been withdrawn. 3.2 on our agenda is continued from November 18th, 2025, case number 146-25, fine respondents Vinbach and Tranthuha at 585 Sky Harbor Drive, number 121, in violation of code for residential business tax receipt, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on that? No? Inspector, you have the floor.
Yes, your board. We're just seeking a declaration of violation on this case. They brought the property in compliance, but it just took them quite a while to do so. So we would like to request that declaration, please.
And you guys are satisfied with it being in
Yes.
compliance and everything? Okay, can I have a declaration then?
I have a question first.
Oh, okay.
And that is, would it be the standard first motion in violation or was in violation?
What was?
Was.
Yeah.
Okay. The full motion, correct?
That's a nuisance
All right.
abatement. That's a nuisance abatement violation.
I have it right here, declaration of violation.
Okay.
Number 2.
I move
page
to
2.
find the respondent was in violation of the code as referred to in the affidavit in this case. the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Next is 3.3 on our agenda has been withdrawn. 3.4 was continued from December 17th, 2025, is continued to February. I'm sorry, I didn't see that one. 3.5 on our agenda is withdrawn. 3.6 on the agenda is withdrawn. Case 3.7 on our agenda, case 01-26, fine respondents Don Martian, Von Burns, Rev Trust at 1535 Gulf to Bay Boulevard in violation of code for portable storage unit, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Would you come forward, sir? How you doing?
Aye.
Will you please state your names for the record to our clerk, please?
Right. My name is Vika Lawson, and I represent Mr. Don Martin from Burns.
First thing I'm going to ask, do you admit or deny the violation?
Deny.
You deny the violation? If you'll have a seat right there, we'll bring the city up to explain the case, and we'll
Thank
get
you.
back to you. Thank you, sir. Hello, Inspector, you have the floor.
Thank you. Vicki Sedek, Code Compliance Inspector with the City of Clearwater. This is for case number 01-26 for 1535 Gulf Bay Boulevard. There is one violation here for a portable storage unit, Code Section 3-2103H1 and H2. Notice of violation was sent on 9/24/25 with a compliance date of 10/15/25. The certified mail receipt was received on 10/10/25. This is a picture dated on October 1st of it's part of a semi-trailer that's parked out there. There is no cab to it, it's just the trailer itself. This is a side view picture of it. This is another picture of it showing that the things that it sits on, they're broken. Closer up photo of that. This picture was taken today showing you that it's still there. The things are still broken. It's being held up by wood. Compliance can be met for the storage container by removing the storage container. Request compliance on or before February 25th, 2026. If the violations continue to exist, impose a fine of $150 per day per violation for each day the violation continues to exist.
All right, thank you. I'll have the, can you come back up, please? Well, you've seen the city's evidence. How are you going to respond?
Yes, so Mr. Von Burns had an opportunity to exchange some emails with the inspector, and the primary concern was, since the trailer was purchased as a mode of transportation to get goods sold at the restaurant to the restaurant, and during the recent hurricanes, it was damaged, and since Mr. Von Burns speaks Polish fluently. I speak Polish as well, so if you don't mind, I will interpret what he's telling. So the damage that was experienced, we actually had a chance to see that the images showed that the legs supporting the trailer were damaged. So while at this moment, Mr. Von Burns is not able to use it for transportation, it was never used for storage. And so that was the primary concern expressed in his emails was, well, I am not using it as a portable storage unit. Could you please provide a definition? Because the handbook, the code compliance handbook fails to define a portable storage unit. And so that's the foundation of the misunderstanding. Okay, that is all.
So you're just saying that it's not being used for storage, but so it's okay to be there? I mean,
So it is a registered trailer. The intent is to use it for transportation and to transport goods that are sold at the restaurant, not to store anything there. Yes, it is currently damaged, and Mr. Von Burns intends to repair it when he has the funds available. He purchased the trailer with funds from loan from the government to develop his business, to grow his business. And yes, due to the hurricane, it was damaged and he's unable to use it at the time, but he never intended to use it as a storage unit. He wants to use it for transportation. That's his goal.
Okay. Now, do you think you're going to be able to have this trailer fixed and moved out of there? Because one way or the other, I don't think it can sit there, even empty or full. You know what I mean? Like in the condition that it's in. So is the February 25th, is that going to be enough time for him to get it back in operating order and get it out of there?
Czy do 25 lutego będziesz w stanie naprawić tą przyczepę? Czyli on mówi otwarcie o tym, że chodzi o to, w jakim stanie jest przyczepa.
Ale powiedz, czy coś przeszkadza, że ona w tej chwili ma złamane to robi przez huragan? Przecież ja tego nie złamałem, tylko huragan to złamał.
So Mr. Von Burns is hoping to clarify, because, see, it wasn't expressed in the notices to him that the primary concern is the condition. Yes, he wants to fix it. He doesn't know if he will be able to do it by February 25th. The business at the restaurant is slower than he expected, slower than he anticipated. However, his concern is he feels that he's being, well, intimidated into, there's a claim that it's a portable storage unit. That's not the case. It's just that he didn't intentionally damage the trailer. It's the hurricane that damaged the trailer.
I understand that.
So
Yeah,
that's his concern.
We just can't like have an open, whenever he gets it done. We have to have a time. We give him to the 25th of next month. If he needs another 30 days, maybe we'll extend it out till March, but we have to have a timeline. We just can't leave it as an open, get it fixed whenever you can.
Mr. Chair.
I have
Yes.
questions.
May I?
Counselor?
Thank you. When this case was initiated, I think we were of the impression that it was being used for storage. That's why the case was put forward under the portable storage unit code. There is a definition for that in our code, and it basically says used for storage. If their testimony today under oath is that it's not being used for storage, then that does contradict what we were initially bringing the case under, the theory that we initially brought the case under. But the fact that the condition of it is kind of a separate issue that was not noticed. The city, and it would be my advice to the staff to renotice, to focus on the nuisance part of it. Given the condition, it's my understanding though that when this first started, the trailer wasn't exactly in the condition. It's actually deteriorated in condition. So the condition it's in is a violation. It's just under a different code section, and I would recommend that we renotice for that section. Whether or not he can continue to park it there, I believe that this is a commercial property, so it's a different type of rules for commercial vehicles there, but that's something that I think we can work out with the staff. I guess I would just say that based on what they're saying, unless our inspector has evidence to contradict the storage component, that is the case that we've brought forward. It doesn't change the fact that the trailer would need to be repaired, but we, as a formality, we would renotice under a different code section for that.
Do you want to withdraw it or continue it?
Well, I guess I would put that to you. I don't know how, and since I've been here, we've not amended our notice
Right.
and continued the case.
Right.
That would obviously be our preference because I'm not aware of any legal reason why we couldn't just reissue a notice and then come back next month.
Right, so why don't we just continue it until pending what the city does with the notice?
Unless our inspector has some evidence to contradict the storage component, and then I would certainly like to hear from her on that part of it. I mean, it's a trailer could be used for that. We were of the impression that's how the case was initiated. The condition of the trailer deteriorated from then. So, do you have anything to add to that part of it?
Sure.
would we want to dismiss it and just have her
Well, let's see what,
reissue
let's see
her
what the
first?
inspector has to say.
You want to step up? Excuse me.
So when I first went out to the property, there were several trailers and food trucks there and several ABVs, and including that semi-trailer. I did speak to a girl there who said that the owner was her husband. He was out of town, out of the country. I went over all the violations with her, and when we got to the storage container, she did express to me that they use that for storage, that it has to be there. They store a lot of stuff in there that they use for the restaurant. I, at that time, explained to her that they couldn't have that there out of storage, and she said that she wouldn't be able to get it removed from the property until her husband got back from wherever he was in another country. And this is where we've ended up because nothing's been done with it. My case is for the storage container. It wasn't for the fact that it's deteriorating. It's been deteriorating for the last 2 years. So, I mean, that's irrelevant to this. This was just because she stated they are using that as a storage container. It has not moved. I've never seen a semi hooked up to it. I've never even seen the semi cab on the property. It's just that container.
So, I mean, based on that, our position is that there is, the board does have sufficient evidence to determine that it's a storage container and that it needs to be removed. Certainly, it's within the board to weigh the evidence and make a decision.
Was there any reason, other than your wife telling the truth, that she would say that you were using it for storage?
Ona w ogóle się mnie zapytała, w ogóle mi nic nie powiedziała o sprawie, w ogóle nic, się dowiedziałem dopiero po fakcie, jak one ze sobą rozmawiały.
So the person that the inspector spoke to at the premises, the wife of Mr. Von Burns, never consulted with him on what the trailer is actually going to be used for. And no, it was not used as a storage.
Powiedz jeszcze, że jak to może być magazyn, skoro tam nie ma w ogóle kłódki, że to można otwierać.
There is no locking mechanism. It's available. You can open the door. Nothing there is of being protected and of value and stored. So that's the position.
Będzie, to ja jestem właścicielem, a nie moja żona. Moja żona tylko tam pracuje.
And
Chciała być miła, ale zrobiła źle.
Mr. Von Burns' wife wanted to cooperate and then try and work with the inspector, but she only works there. He's the owner of the restaurant, and he wasn't consulted on it.
But his wife doesn't know, I mean, like my wife knows what's, going on my property. That's what I'm saying. It just, and she has no reason to perjure herself
Right.
in front of here. So I'm going to take the testimony as truthful.
Right.
And that his wife did say that there was being stuff stored in there.
Right.
Board, do you have any other questions that's my opinion on it.
I'm kind of ambivalent on it in that I think that, I understand she said it was used for storage. I don't see any photos of, stuff being stored in it, so I don't know one way or the other. I mean, I believe what the inspector's telling us and what she said. I think that based on Jared's statement that there are perhaps other causes of actions that are pertinent to, also pertinent to the existence of it there, that perhaps we should let the city revisit it, and that's my, unless somebody wants to call it a violation,
Okay. Board, do you guys want to weigh in on this? Do we need to come up with that?
It's rough knowing which way to go because, as Bob said, there's no picture of evidence of anything in the storage unit or the trailer. So it's kind of hard to decide.
Well, do we know whether it's violating another code or not?
It is,
But that's
it
why-
is,
Okay.
but
So,
they
is
wasn't
that the-
cited for that. We're only cited here for storage, not,
Yeah.
Well,
not the condition.
And that's the basis of
So that's why-
referring it back to the city to
That's why I was saying.
pursue
we-
other causes under the code for
We can-
correcting whatever needs to be corrected.
We could dismiss this and then they could go back with a,
Well,
With-
yeah, do
withdrawn.
we continue this one and start up the second one and try to confirm one way or the other by looking in that trailer?
Our preference would be to continue, because, you know, we have noticed they're obviously participating in our process. They're here today. This is not an imminent safety issue. This is an aesthetic and, you know, neighborhood aesthetic issue that we're trying to, you know, make sure everything looks nice. It is a commercial property, so they do have some rights to park commercial vehicles there, and we obviously want to respect that. I understand this business has been there for a very long time and has been in our community for a long time. So we're very sensitive to all those things. We're willing to work with them. The fact that they're here participating in our process is good. And so we would just ask to continue rather than dismiss, because if we don't need to necessarily start over. There's lots of different ways that this can be approached. So I would just ask for a continuance, and then I can work with the staff and hopefully work with the property owner, and we can try to figure out a reasonable solution.
okay.
I have a question for you, Counselor. If we move to continue, what time frame would be appropriate? 30 days, 60 days?
We can put something together very quickly, and then we will file with the clerk, whether it be a supplemental notice or something to that effect, but we just asked to go to the next meeting.
Okay. All right. That sounds all right with me. Board, does that sound? Okay. All right, can I get just a motion to continue this until our our February meeting?
I move to continue case number 1-26 to the March meeting, and the date of that?
It is,
February 25th, to the February meeting, February 25th.
A second.
all in favor?
Aye.
All opposed? All right, motion carries. We're going to continue it until next month.
Thank you.
Uh-huh.
Thank
All
you.
right. Next on our agenda is 3.8, case number 02-26, find respondents Gilbert G. Janelli at 1411 Gulf to Bay Boulevard in violation of code for exterior surfaces and roof maintenance, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Can you come forward, please? If you will, state your name and address to our clerk for the record.
Sure, Gilbert G. Janelli, 909 South Fort Harrison Avenue in Clearwater, 33756.
All right, Mr. Janelli, are you admitting or denying the violation?
Admitting,
today?
there's violations there.
Admitting the violation today?
Building needs help, and we got a plan.
Okay, well, thank you, and have a seat right there. And we'll,
My new tenant is here to speak as well.
okay, can I get a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Inspector, you have the floor.
Vicki Sedith, Code Compliance Inspector with the City of Clearwater. This is for case 02-26 for 1411 Gulf Bay Boulevard. There are two violations at this property, the first one being exterior surfaces, Code Section 3-1502B, and roof maintenance, Code Section 3-1502D1, D3, and D5. Notice of violation was sent on August 28th of 2025 with a compliance date of 9/28/2025. The certified mail receipt was received on 9/15/2025. This is a picture of the building of the, it's kind of the front side. This is actually this, there's Gulf to Bay in the front, and this is the parking lot that connects to South Hillcrest. Here's a picture of some of the roof damage, some of the exterior. This is the side back view, hole in the roof. This is leading up to the stairwell. This is some of the concrete that's coming off the wall. Some more wood rot and damage. Again, just a full picture of the different paint schemes that are going on. So then he went back, had somebody go out there, and you can see up in the corner where they took a soffit and just tried to cover up the rotted wood that was along the roof edge. There's still more soffit falling down, a lot of mixed matched paint, some things that weren't painted at all. There's a hole in the wall right there next to the door on the left. Nothing was done in the back. This thing, I had pointed out to him on Monday that how dangerous it was and it was falling down, and when I went out there today, it had completely fallen down off the side of the building. More peeling paint to the stairwell, peeling paint on the side, soffit still falling down. Some stuff still not painted in the front of the building. Again, the front of the building, soffit falling down, part of the roof missing, the hole still in the wall, or the hole still in the roof. Compliance can be met for the exterior surfaces by replacing any defective structural and decorative elements of any building wall and ensure all exterior surfaces are free of mildew, rust, loose material, and faded peeling paint. Patching, painting, or resurfacing shall be accomplished to match the existing or adjacent surfaces as to the materials, color, bond, and joining. Compliance can be met for the roof by fixing all holes and maintaining the roof in a safe, secure, and watertight condition or replacing the roof. Request compliance on or before February 27th, 2026. If the violation continues to exist, impose a fine of $150 per day per violation for each day the violation continues to exist. And there are 2 violations there.
Board, do you have any questions for Inspector?
Not at the moment.
Mr. Gianelli, can you come back up, sir?
Yes, sir.
You think you're going to be able to get all this done by February the 27th?
No, sir, I've done magic before, but that's a challenge.
So what's your timeline you're thinking?
Well, we started to work on the building, and then we had 2 contracts blow up on us for financial reasons. The prospective tenant couldn't obtain financing to go along with the city grant that's being offered in the East Gateway area. I've owned the building for a long time. We had some very successful tenants in there in the beginning. Unfortunately, the city allowed the soup kitchen to move into its present location. And in my opinion, that's one of the big death knells of the East Gateway and even parts of downtown. Things are looking a whole lot better. The sound has been a great asset to the city. There's new construction going on downtown. The Church of Scientology has done remarkable with a lot of their properties. They have remodeled them. They're out for lease. There's interest. However, it's still slow downtown. It's still slow in the East Gateway. You've got probably one of the top realtors in the city of Clearwater here that can testify about downtown real estate. She knows probably every piece. So the building has been a challenge for what is the highest and best use for the property. It may not be a restaurant. It may be to knock it down and build some housing there. But fortunately, I have a new tenant who is proven in the area. He's been has a very successful business. And we've looked at the building extensively, and he is assured us that he can make things work there. So the process for that being is that we can apply, the city through the CRA has grant money available for rehab. That takes time. So we have to apply for the grant. That takes anywhere from 1 to 3 months for that process to occur. If we're given the grant, then it's going to take another month or 2 to draw plans, submit it to the city for approval for construction to get through a general contractor to get a permit to rebuild it. And then it's going to take 6 to 8 months for construction to finish it. We're not talking about just what's here. We're talking about renovating the entire building, both inside and out. That's our plan. And that figure is going to be about $1.2 to $1.4 million of cost. So we're not talking about just fixing what's here. We're talking about completing the entire process. And in good faith, because the roof does need work, I've applied for a roofing permit, and that's I don't know if it's been issued yet, but it's in the application process through Baker Roofing, which is a local roofing company.
Well, unfortunately, we're not gonna be able to give you a year and a half to get this.
No,
thing.
no, I understand.
So what about the exterior surfaces and the roof maintenance? Can that be accomplished within, by our March meeting? instead
No,
of February?
it cannot, because here's why. If we don't know exactly what we're going to do with the roof, we may take off the second floor and put a deck there. We have to see if the city will allow us to do that. So that could be pretty quick. And we've done this in the past, or the city's done this in the past. We can set up every month or two, we can have a continuation. We can update the city staff as to what we're doing. They can be right along with us in the permit process. I understand that you can't give me all this time, but we don't want to just fix what's here and then have to redo it if we renovate the entire building.
We're just trying to get you to come into compliance.
I understand
on
that.
this case.
So all the little Chinese things that happen, that's all coming off. That's not going to be part of the new, that's going to be, the whole structure is going to be completely different. So if we just Band-Aid what's here, in 3 or 4 or 5 months, all that's going to come down, and I'd rather, spend the money to rehab the whole building. It's a different case, and I understand we need some cooperation between the city and Ms. Mulder. She's not here today, but she said, if we're in the process and we're in the grant process, they will work with us. We didn't come to specific, what does that mean, but I think as a solution, if we have periodic updates with the board, I can come back here, or with city staff, or both, that will keep you abreast, and we're going to move as fast forward as we can, as the city will allow us to do.
I mean, there's a lot of future unknowns for you, though, How much is the grant going to be? What are you going to be able to, is your guy here, is he going to be able to come through? There's a lot of gray area, man.
There is, but we've been encouraged by the CRA to apply for the grant, for grants. We have, the funds are available to cover the work, or I wouldn't be here today.
Mr. Dinelli, have you looked at the estimated or evaluated the cost of just coming into compliance with the existing violations?
Well, to fix the building outside properly, it really needs to be re-stuccoed.
Understood. Well, I understand that as a contractor. I'm looking at what violations the code enforcement officer has brought and what it would require to get into compliance with those. Understanding what your long-term intentions and plans are and all of that.
Right.
Because of the time involved, it seems in our world it's quite a long time in order to correct violations. So I'm focusing on what would be the cost, the minimal cost to get into compliance with the existing violations that the inspector has shown us.
We had a quote for a roof of about $40,000. We haven't not bid out the rest of it to come into compliance. But once again, we may take, if you see the building, and you can certainly go out, and I'll be happy to meet you there and show you what we're going to do, but we may take off the second floor.
Right.
If the city will allow us to put a deck on top of the building,
Right.
then we're going to take out the second floor. So doing the roof would do the roof and then take it out.
Understood. Again, I'm looking at focusing on the code compliance case, understanding what your long-term plans are, and I think that's great.
Yeah. I mean, we can fix some holes, we can replace the rotten wood, we can paint the building, but and I don't mind doing that. I'll be happy to do that. But we're going to re-stucco the whole building.
Understood.
And we may change the front doors, we may change the windows, we may add doors, we may subtract doors as part of the total rehab of the building. And you know you're in construction, so you
Yes,
know
sir.
what we're up against.
What's
Yeah, I
plan
understand.
B if you don't get the grant?
But, he says we'll
Do
get
all
the
the
grant.
work that we were just talking about?
Yeah.
Okay.
Or if we don't get the grant, then I would get some opinions by like Ms. Anderson, as to what would be the highest and best use for us to do with the property, which may be level the building and build housing. There are a lot of good realtors around that know Clearwater better than I do. So that would be an option that we have.
And are you gonna be pursuing the grant and pursuing the city's permission to do what you want to do?
Absolutely,
at the same time, concurrently?
Concurrently.
Okay. I say we do 90 days, have him come back. If he doesn't have the grant, then he's gonna have to go forward with the cleanup. And if he's got the grant, then we figure out the time plan then. Does the city have any?
I don't have anything to add. I guess I don't know if staff wants to comment on any of what's been said.
Yeah.
Yeah, I think
Kevin wants to
our
say
building
something.
official would like to have a word.
Yeah. You step forward, sir. We hear all sides here, so we can figure out what to do with this place.
I'm Kevin Garrett with the Building Department, City of Clearwater, building official. And I just want to let Dr. Janelli and the board know that we get inquiries from the CRA all the time about their loans and their grants, finding out if people have code violations before they get any approval to grants. So that needs to be considered. You need to be aware of that, and don't count on something if, I don't know all the details, so I can't go into great explanation, but I know they check with our office all the time on that sort of thing.
For code violations before any grant money is
Right.
awarded.
Does that mean
So
that?
somehow they're connected. I don't know how, that would need to come from them, but I know they check with us all the time.
Would you be able to tell us definitively, or tell us one way or the other, if there are violations on a property, that it limits or accepts the grant till the violations are corrected? Is that how it works? Do you know?
That answer would need to come from the CRA, not me.
Yeah, if I may, if there is more questions about the grant program, I would ask if we could bring that back to you next month. I would assume that there are occasions where we do provide grant money on properties where violations occur, but I would assume that all of those violations would need to be remedied as part of the expenditures of the grant. So that could be, but I'm not personally familiar with the grant program that he's discussing, and I haven't been involved in any of the conversations that they're talking about, so I can't really help. But I would prefer a shorter time than 90 days if there's just to answer these questions about the grants and things like that. We could come back next month and we could tell you what grant programs that they're looking at, what the requirements of those programs are, all that stuff. We could get that information to you pretty quickly.
I have a question. Dr. Janelli, would you
Yes,
be
ma'am.
able to fix the unsafe areas? Maybe cover that hole into the building, maybe slap some paint on so that it's all consistent, like do some minor until you get the grant so that there aren't such, terrible outpoints on the building?
Yes, Ms. Anderson, we were doing that, but then we had a prospective tenant, so we stopped because they wanted to redo the whole building. So we were working on that. You can see some of the pictures in the beginning from what they are today.
Right.
So we were moving forward with that
Okay.
to do the bare minimum.
And could you do that within the next 30 days?
I could attempt to do that. The roof that's going to be a problem.
Right.
That's going to be the biggest, the grounds and the building, that's much easier to handle than a $40,000, $50,000 roof.
Right, exactly. Okay.
So we can make it safe outside. We do have, a huge homeless problem. There's trash there. My guys go out every 2 or 3 weeks, and every 2 or 3 weeks, there's 6 bags of trash from homeless people because the property's vacant.
Have you considered looking at, rather than replacing the roof, because I understand that what your long-term plan is based on what you've told us, have you considered having the appearance or the roof repaired to satisfy the appearance issues until you do your major project.
I'm not a roofer, but I've had 3 roofing companies look at that. That was my first choice. And we didn't ask the 3rd roofer who got the permit whether he would be willing just to repair it. But there's apparently some liability on their part that if it's not done to code, then they have a responsibility for that as a roofing company.
Gotcha.
We lost a lot of shingles in the couple holes in the roof from the hurricane.
Gotcha.
I mean, we could fix the holes in the roof. We could certainly put some shingles back, but it's not going to be. The roof is still going to needs new shingles. It needs other wood replacement and other things.
Understood. I'm thinking, again, my focus is based on the case before us in terms of the appearance and satisfying the code compliance issues with the code compliance officer. And if you're able to make that go away, then you're satisfied here and you can rock and roll with your future project.
Right.
So my focus is on what's a workable, reasonable way and amount of time to make the code compliance issue go away so we can resolve this case.
We can make it all go away. It's going to cost about probably $100,000, maybe more. But then we're going to redo it if we move forward with redoing the building. Everything we would do to Band-Aid the problem now would have to be redone if we're going to rehab the whole building.
Understood.
In 6 months.
Understood.
That's the dilemma. It's a two-way street here. We're looking for a little bit of room to work, and we were led to believe that the CRA knows the condition of the building, and they've encouraged us to apply for the grant. Mr. DeLanga can speak to that, and he has experience with the CRA presently with his business and the property.
Okay, understood. I believe Kevin wants to say something. Mr. Garrett.
Kevin, would you step forward, sir?
Yes, thank you. I have one other thing to add, that we just checked with the permitting status, and with the exception of one document, the roof permit is ready to issue. So that's just filling out a paper and signing it. So
Gotcha.
they virtually have a roof permit right now.
But that's for the roof, the current roof, not taking it off and doing their deck if they get the grant.
I would presume, but I don't
Yeah.
have the documents in
Yes.
front of me right now.
Dr.
so-
Janelli saying yes, okay.
Yeah, it's for a re-roof in its present condition. And the roofer said that he's done work he's got grants from the city as well, and he's worked with the city, Baker Ruby. And he's willing to work with us in the grants, in getting the grant to help with the rehab. So he's aware of all that.
Yeah, we want to try to, we want for you to get the grants, and we want you to get the
Yes.
building up, and and we definitely want, new businesses in Clearwater and stuff.
There's nobody,
But we've got to resolve this somehow, and with, just our main 2 things, the exterior surface and the roof mason. We can't wait for, maybe a grant, maybe not, maybe we're going to tear the roof off, maybe we're not. There's, you brought us nothing concrete for us to sit and decide to in your favor,
right.
about it. You just keep giving us these scenarios where it may happen, it may not. We can't go on that,
Well, I think,
we want to work with you, but, she was showing us pictures from back in October, so it's been, 3 or 4 months.
yeah, hold on.
If you can wait like 60 days, I talked with CRA, I think we got approved for 800,000 to finish this, and only I need like 3 contractors to give me all estimate for inside, outside, should be all done.
Can't hear you. Got you.
You're talking to the mic.
Yeah.
I need like 3 contractors to get me estimate from inside, outside, and I'm ready to talk with the city of Clearwater. I think they ready to give me like around 800,000 to fix everything inside, outside. We need like 60 more days to finish all the paper to city give us approval for all these things.
I don't have any problem giving them out until our March meeting, but
Yeah.
that's,
Yeah.
we'll go ahead and with our second motion and just change that February to the March.
and then you want to ask for an update, or you
And-
want to establish fines at that point?
Well, you know, we'll ask for, definitely ask for an update from at least the inspector, as long as she, you know, continues to, as long as Dr. Janelli keeps in contact with our inspector, you know. I mean, that's where I would be, so. I mean,
Mr. Chair?
Yes.
If I may, in the past, we have had exterior surface violations where, you know, they look superficial, and then as they get in, they realize there's a lot more work that needs to be done. They pull permits, and we wait to file the affidavit of noncompliance, and we let them work through the permit before we file that affidavit. Because as you know, you give a deadline, the city has to file that affidavit of noncompliance to actually trigger the fine and come back to you to get approval of that. So.
Now, is that determined on our deadline? I mean, if it's not done by like the 25th, it'll automatically trigger that?
No, that's what I'm saying, is that you give us a deadline, and then on the day after the deadline, our inspector goes out to the property. If it's still in violation, they write up a document called an affidavit of noncompliance. You see those on your agenda as well, and we bring it back. But obviously, that's a determination for the inspector to make at that time, the day after the deadline. What I'm saying is that in the past, we've had situations where exterior surface violations open up to become a lot more. We've paused, even though technically they are in violation the day after the deadline. We wait to file that affidavit. We let them work through the permit. We let them, you know, comply with the inspections and go through the permitting process. And then we either file it as complied if that happens, or we file the affidavit of if it gets stalled for some reason, we bring that affidavit of noncompliance at a later time. So that's what we would suggest here, is that if you impose a deadline, if you move it out as you were discussing, that you move the deadline out a little bit further, give them a little bit more time. They apply for the grant, they get the permit, everything looks like it's moving. We can pause on filing that affidavit of noncompliance and let them work through those processes.
And I can assure you, when we start to fix it, we're gonna run into, I've already gone down that route with the contractors, and to Band-Aid the stuccos, to Band-Aid the cracks in the walls is a bigger job than just
We understand.
putting a little mud on it.
We understand. That's why we're trying to.
Yeah.
We're trying to find a solution here that kind of like covers everything and makes everyone.
If I could suggest, in a couple of months, we'll have a good direction from the CRA in the grant, and we'll know exactly where we'll be. And if we get, in our first meeting with them, if we get positive direction, we'll start moving ahead with plans and everything else to expedite the time. Time is money for us as well.
Board, do you have any problems with extending this out to our March 25th meeting? We're going to go ahead and we're going to go ahead and with our second motion, we're going to give a deadline of March 25th of our meeting.
No.
And then, just like he said, you know, Jared said that if they show, you know, stuff's moving forward and everything, they can go ahead and, with permits, they can go ahead and let them work, and they don't have to immediately file on the 25th if he hasn't got, you know, if the inspector shows that there's progress being made, then they can, like council said, they can work through the permit and not start accruing fines. It would be up to the inspector for that paperwork.
The one question I have is, or what we'd like to know, and you could probably know that by next meeting, is are they required to correct code violations before they get the grant?
This would be dependent on the grant program. You know, CRA has a
Right.
lot of different grant programs. Some of them are
So we can't
contingent
really
on
determine
federal
that by next
requirements
meeting?
and things. I'd have to know what program they're
Okay.
looking at, and then be able to look at those particular program
Well,
rules.
that would expedite it a little bit, but absent that, I mean, you know, 60, 90 days, he said 1 to 3 months, to, you know, so if you want to come back in 2 months and then ask for another month, you know, or we can just.
Well, that'll be dependent on what the inspector finds on March 25th, you know. If she goes out there and sees that there's, you know, he's got the roof permit and she sees stuff happening and progress is being made, then she doesn't have to fill out her, affidavit of noncompliance. She doesn't have to fill that paper, start that paperwork. You know, she can come back to, you know, and say, hey, She doesn't even have to come back to us. If we don't see it on our docket, then we know that there must be progress being made, you know? So, and if not, she'll be here on the 25th saying with an affidavit of noncompliance for us to, you know, approve. And then the fines will start back, you know.
Okay, well, that's the middle ground.
Yeah.
Dr. Genelli has a question.
I'm getting a little confused. We could go out tomorrow and make the building safe and secure all that. As far as painting and fixing the stucco and all that, and even the roof, that's expensive. And we'd like to certainly qualify for the grant if that's possible. Now, I understand there's different grants and there's different scenarios with the grant. We have been led to believe that the grant is going to be issued regardless of whether there's code violations or not. But within a couple of months, we're going to know one way or the other where we're going to get the grant. They may not grant the grant in 2 months. It may take a little longer for the paperwork, because I understand the city council has to sign off on the grant after it's approved. And that may take a cycle of 30 days, so, you know.
I think our general.
Even the grant's approved, I believe the majority of the grants have to be signed off by city council.
Well,
I think,
go ahead, Mr.
I think
King.
our general understanding is that if there's movement in that direction,
Yeah.
then, you know,
We're gonna give you
the
an
city
extra
has
30
the
days.
opportunity, the code compliance,
Yeah.
and the city has the ability to give you some latitude.
Yeah.
So,
Cool, good.
so even though we set a date
So-
on this, that you still have
It all depends
that
on
latitude.
what your inspector comes out and finds on the 25th of March.
We'd like a working relationship, that's
Oh,
what we'd
yeah,
like to do.
yeah, of course, definitely.
Mr. Chair, and I'll also add that if the board does find a violation and pose a deadline today, like you said, it would not come back if we did not file the affidavit of noncompliance. But if we did file the affidavit of noncompliance, that would come before you all, and we have had situations where, you know, even though that's a straight determination, was it in violation on that day or not? We've had the board have questions, and we've postponed decisions on accepting those affidavits pending the outcome of those questions that the board had. So that would be another option, and that gives the city at least the assurance of having some kind of hard deadline in place.
Okay.
Because, one more thing, if you go through with that, the compliance may not happen for 10 months or so, but
As long as you're in contact with this lady right here, then, you know, she controls the pen stroke of that affidavit of noncompliance. So if we give you 60 days, and she comes out there and you haven't done nothing, and there's more stuff falling off the building, she's gonna write that affidavit of noncompliance.
well, but see,
But if
so
not-
what I need a little more direction as to what
Exterior surfaces and roof maintenance, I can't make it any clearer than that. So in 60 days, if we go that route, you need to show some sort of improvement in your roof and your exterior surfaces. And that would be up to her to determine, you know, if it's, because we can't put it out for a year, 2 years until, like I said, there's too much gray area here, doctor, you know, that we can't just leave up in the air. You know, we have to, you know, we work for all the citizens of Clearwater, not just, you know, one person that owns a building.
I understand. Well, I mean, we can plug the holes in the roof and put new wood in and put a few new shingles here and there, and that'll.
Whatever you.
But it's not gonna look like it should, and the building isn't gonna look like it should, because
We're
and
not
part of the outside of the building is gonna be demoed anyway, so.
I don't think you're understanding what we're saying.
Yeah.
As long as she sees progress on the 25th of March, I don't know what that progress would be. You're throwing out a scenario that's not even happened yet.
Okay.
And you're trying to gain more time, and it's just not gonna happen, you know?
No,
I
we'll.
think 60 days is gonna be,
We'll make some movement.
you know.
Don't have a problem with that.
All right, if I can get a second motion on that?
I move to enter an order requiring the respondent to correct the violations on or before March 25th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, second motion. Thank you. All right, next on our agenda is 3.9, case 03-26. Fine respondents Kathy Varro at 1910 Union Street in violation of code for exterior services, roof maintenance, door and window openings, exterior storage, and public health, safety, and welfare nuisance, pool, and issue an order with compliance deadline if fine and compliance is not met. Is there anyone here to speak on that case? No? Inspector Caspen, you have the floor.
Hold on a second. Give it a second, it's loading in. Good afternoon, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is case number 03-26 for 1910 Union Street. There were 5 violations here for Code Section 3-1502B for exterior surfaces, Code Section 3-1502D1 and D5 for roof maintenance, Code Section 3-1502C1, C3, and C4 for door and window maintenance, Code Section 3-1503B5 for hazardous pool, and Code Section 3-1502G1, G2, and G3 for exterior storage. These are the dates of the notice of violation were set out with the compliance date. Did the affidavit of posting the same day of the notice of violation with a notice of hearing posted for today's hearing on the 15th of this month. This is 1910 Union Street. I had noticed when I drove by that the garage door was falling out of the garage. When I got closer, many items being stored outdoors in the premises. Some damage to the fascia there on the garage. A next door neighbor called me and complained about the rear of the property. There was a bunch of stuff being stored outdoors, and there's also damage again to the fascia and the soffits, some of the exterior. The pool was green. This is the date of my affidavits of posting on the 14th of October. This is my pictures of the compliance date afterward. The garage door is still damaged, falling out, damage to the roof there in the rear, hole in the side of the building, damage to the roof and soffits. The pool hasn't been cleaned. All the items are still in the yard. This was the notice of hearing for today's hearing on the 15th, posted. It's a closer look up front. Here were the photos of today, pretty much the same. Some damage to the roof corner. The rear of the property is still in the same shape. Still got a hole in the wall up there. And the pool still hasn't been cleaned. So compliance has been met for the exterior surface by repairing any damage, removing any chipped or peeling paint, repairing or repainting where necessary. Compliance met for the roof maintenance by repairing any damage to the roof fascia and soffits. Compliance met for door and window maintenance by repairing the garage door, repairing and replacing any damaged windows or doors. Compliance met for the hazardous pool by cleaning the pool and ensuring the water is clear by draining the pool completely. Compliance met for exterior storage by removing from the grounds of the property any appliances, furniture, buckets, bins, tires, shopping carts, motors, and other miscellaneous items not meant for outdoor use. And I'm requesting compliance on or before February 28th, 2026, or a fine of $150 per day per violation for each day the violations continue to exist.
Is there anyone at the property?
The story I've gotten from neighbors and people in the neighborhood is that the property was owned by a Gabriel Varro, and he had a wife and a son, and Gabriel passed away. The wife's name is Kathy Varro, and Gabriel Jr. resides at the property, but Kathy Varro is incapacitated in some way, and no one really does anything with it. Gabriel just lives there with some other people, and their property is also in foreclosure right now, but like I said,
It's probably another reason they're not, you know.
yeah, so it's probably what's going to end up happening is the bank going to come in possession of the property and probably take care of the violations, but I just want to make sure they were addressed and the neighbors also had complaints about them.
Do you have any, Board, do we have any questions for Inspector Casman? No. Can I get a first motion?
Do we want to change that date from the 28th to the 25th when the board meets?
I was just given 30 days for it's 30 days out from today.
Yeah, I don't know if that's,
I wasn't trying to do it off a meeting.
that pushes us into the next meeting, but.
I mean, I don't have a problem. I mean, do you have a problem with 27 days or 28 days instead of 30?
Well, I don't mind either way. It's just when I go to file the affidavit of noncompliance, if they don't come to compliance, you're not going to hear it at next month's meeting anyway.
Exactly,
Yeah.
right.
It's going to still be
You won't hear
45
it till
days
the
out from
following
whenever I
meeting.
send it.
Okay.
So it doesn't
But yeah.
matter.
Then it doesn't matter.
Okay.
So, can I get a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I second it.
All in favor? Aye. All opposed? First motion carries. You get a second?
I move to enter an order requiring the respondent to correct the violations on or before February 28th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, second motion carries. Next case is 3.10 on our agenda, case number 04-26, find respondents Lee Coriel Estate at 315 North Corona Avenue in violation of code for roof maintenance, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No. Inspector Cashman, you have the floor.
Good afternoon again, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is case number 4-26 for 315 North Corona Avenue. There was one violation here for Code Section 3-1502 D1 and D3 for roof maintenance. These are the dates the notice of violation went out, with the affidavit of posting being done on the same day as the notice of violation. I understood that the gentleman here had passed, and I was in contact with someone claiming to be one of his heirs. They did end up maintaining the yard and putting the address on the property. I was in talk with them about the roof and what they were planning on doing with it, and then I haven't spoken with them since. They haven't tried to get back in contact with me. But this is 315 North Corona Avenue. If you notice there's a fair amount of pine needles on the roof, but at the upper left, you see there's a tarp that's being held down with logs on that portion of the roof. This is a look from the side.
I think I know where them logs came from.
Well, I'm going to assume maybe the end of that pine tree, but you look in the back, there's a heavy mat of pine needles that's been accumulating on the rear of the property for a while on that roof.
Thatch roofs.
Oh, yeah. I went back into the compliance date. That's just the other side of the property. They still had the large mat of pine needles, and they still haven't repaired that section of the roof. Here's the notice of posting, or the notice of hearing for today's hearing on the 15th. And then from this morning, same issues with the property. So compliance met for the roof maintenance by removal of the tarp from the roof of the home, repair any damage to the roof, removal of all pine needles and branches from the roof of the home. And I'm requesting compliance on or before February 28th, 2026, or a fine of $150 per day per violation for each day the violation continues to exist.
Board, do we have any questions for Inspector?
No.
Can I have a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Second.
I move to enter an order requiring the respondent to correct the violations on or before February 28th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. All right.
Thank you very
next-
much, Board.
Next case is 3-11 on our agenda, case 05-26, find respondents Thomas Rakowski at 1384 Seabreeze Street in violation of code for parking lot services, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No. Inspector Jensen, you have this floor.
Good afternoon, Board. Dave Jensen, Code Inspector of the City of Clearwater. This is case 0526 at 1384 Seabreeze. I have one violation for 31502K4. It has to do with parking lot surfaces and driveway surfaces. I put in the language for that ordinance in here so you can take a look at it. It's not something we deal with on a regular basis. Basically, owners have to keep driveways, parking lots clear of obstructions, et cetera, so they can be used for their intended purpose. This property has been an issue on several different fronts. He is currently just over $526,000 in liens against the property, accruing at $450 a day. You'll recognize the property when I bring it up here. These are the dates of the notices that were sent. This is the property in question. You have heard it before for the motor home being parked where it's at, some other things here. Mr. Duskowski and I have had numerous emails and verbal conversations with in-person conversations with each other about the property and the things he's done there, this being one of them. You can see his driveway. Our right-of-way for the city is actually right about in here. So he's only got this much driveway left, and he has blocked the rest of it off with railroad ties and palm trees. He did have numerous conversations as well through emails with our zoning department. One of those subjects at our zoning department was actually the head of zoning. He finally had to inject himself into the conversation with one of our zoning people about the use of the parking lot because he said he was going to start using it as a patio, and that's one of the reasons he's put these out here. Unfortunately, not only has he blocked it off with the railroad ties, but now the trees, as you'll see here, are starting to die. Some that he's had out in the front lawn are dead as well. So this is the rest of his parking area up here, which he has blocked off and is now unusable. This is back on December 4th. You see how overgrown some of this stuff has gotten. There's grass that you'll see in a picture here that is long and overgrown out from underneath the railroad ties. This is the condition on the 27th of this month. As you can see, these are not being taken care of. They're dying off or dead. This is yesterday as well. This footboard was out in the middle of the yard yesterday. It's since found its way up into the driveway area. This is the overgrowth and the junk that's starting to, or has been accumulating in front of the railroad ties from the street side. More of that junk, dead debris, and everything else obstructing the parking surface. That's the footboard, and you can see the condition of these palms are not doing very well. Compliance can be met for the parking lot surfaces with the driveway and parking surface must be clear of obstructions, barriers, plants, trees, any other objects that would preclude the use of the parking surface as approved in the original site plan. Requesting compliance on or before 2/20 of 26 or a fine of $150 per day for each day the violation continues to exist.
All right. Any questions for Inspector Jensen, board? I don't have any questions on that. I remember this property though.
I do have one question. Based on our experience prior to this, am I correct in thinking that the owner just doesn't care to comply or just wants to do what he wants to do? I'm
Correct.
kind of trying to read this thing.
To say that I've had numerous conversations and emails back and forth with him and again with our zoning and everyone else. If you remember, when the motorhome was parked there were conversations. It was really an in-out vehicle. He did put a plate on it, brought it up to date. However, he left it parked there. He said he was going to have a parking surface put down. I told him that he would have to get a permit, but due to where it's at, right on the property line, et cetera, he may not be able to get that permit.
Didn't he put pavers down or something like that?
Yeah, so next thing you know, they weren't even actual pavers. They're the 3 by 3 or 4 by 4 piece that your exterior air conditioner heater sets up.
Yeah,
So
the
they aren't even
pads, yeah.
pavers.
I
He put
remember
those
this.
under there, and then he wrapped the bottom of the motorhome in a tarp
Yep.
or some material to hide what he'd done there. It's
Yep.
just been, everything that he's done on the property, I've tried to warn him ahead of time and told him you're not allowed to do that or it's just going to cause further issues, and he's just gone ahead and done it. We've had absolutely no luck getting him to bring the property into compliance. And obviously, again, you know, he's well over $500,000 in liens for other violations. So
Yeah.
unfortunately, it's just where we are. I've had neighbors complain about the property. That's where this all started at. Have a neighbor across the street that's trying to sell their houses. They've retired and want to move out of the area. And when I've been down there, they've come out and expressed their aggravation at the fact that it looks the way it does. So,
Hopefully, we can give them some affirmative relief
yeah,
today.
hopefully.
Board, do you have any questions, any more questions for Inspector Jensen?
No.
Can I get a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Can I get a second?
I move to enter an order requiring the respondent to correct the violations on or before February 20th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, second motion
Thank you.
carries. Thank you, Inspector Jensen. Next case is 3.12 on our agenda, case 06-3 26, find respondents MHH Clearwater 395 Holdings LLC at 395 Coronado Drive in violation of code for prohibited signage, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? No. Inspector Burkhart, you have the floor.
Good afternoon, Board. Stephen Burkhardt, Site Inspector for City of Clearwater. That case 6-26 is in compliance as of today. I would ask the Board for declaration of violation.
Can I get a declaration of violation?
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
And a second?
Second. Yeah.
All in favor?
Aye.
All opposed? All right, motion carries. Next case is 3.13 on our agenda, case 07-26, find respondents Mary G. Realty, Inc. at 490 Mandalay Avenue in violation of code for sign maintenance, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak for that case? No? Inspector Burkert, you have the floor.
Stephen Burkhardt, Site Inspector for the City of Clearwater. This is case 7-26 for 490 Mandalay Avenue. There are two violations. First violation is regarding Code Section 3-1806A, temporary sign criteria and limitations. The other violation is regarding sign maintenance. That's Code Section 3-1502I. Notice of violation was mailed July 29th, 25, but certified mail was not signed. So that's why I posted the property in September 4, 25th, and compliance date was October 6, 25th. So the first violation regarding temporary signage was about banner signs. So as you see here, a banner sign can be displayed for up to 1 month per year per parcel. So one sign for up to 1 month. It's just a temporary sign. It can't be longer than 30 days. And that sign picture is taken in June 9 last year. And as you see, that's the pictures from September 4th. The sign is still there, the exact same sign. That was in December 6, 25, and there's another sign displayed, so there are now 2 banner signs advertising for that business. You see that's the other sign still there. As of today, all signs have been removed, so there's no banner signs anymore, so case is in compliance for that. The second case is regarding sign maintenance. The second violation was regarding sign maintenance of the freestanding sign for the plaza. As you see, there's rust and peeling paint on the pole. There's more rust on top of the pole, the sign, so the sign needs to be, the rust needs to be removed and the structure painted. Picture is from today. There's no maintenance being done, still rust and peeling paint visible. As you see in the lower part of the sign, still the same situation. I attempted to speak with the property owner. I spoke with the tenant, Clear Sky. The manager, Stephen, gave me the number of Nick is his name. He's supposed to be the property owner responsible for property. I called him. There's no voicemails being set up or anything, no answer. So the only contact I had was through the posting, basically, of the property. So I had no direct contact with the property owner. Compliance for the freestanding sign in need of maintenance can be met by repairing or removing the sign and the sign structure, or repairing or removing. So that would be the option, basically, just to paint it or remove the rust. That would be the ideal solution for that. You can also demolish the sign if you Compliance for the banner sign can be met by removing the banner and refrain from re-erecting one until all the criteria and limitations can be abided by. So the banner sign has been removed, so it's in compliance, so I asked for a declaration of violation for that violation. So for the other, for the sign maintenance, it still needs to be painted. So recommendations for the case 0726 is the temporary sign violation don't exist anymore, so it's in compliance, it's a declaration of violation, and for the sign maintenance, it still needs to be maintained. Requesting compliance on or before February 28, 26. If the violation continues to exist, impose a fine of $150 per day. Each day the violation continues to exist.
I have a question. On the, even though we're going to give a declaration on the banner signs, is the Mary G. Realty Inc., the owner of the plaza, are they responsible for those banner signs?
Yes, sir. Yeah.
Oh, are they? Okay,
Yeah,
I didn't
they
know
are.
if the business was responsible for them or if they were.
No, all the cases, the two cases going against the property owner. There are several tenants. There were previously other tenants who had banners erected, but it's all the same. So if another tenant starts to put banners out, it's the same violation. But I talked with Clear Sky, of course. I talked with individual businesses, but it's still the property owners responsible.
No worries. The board, do you have any questions on this one?
I do not.
Mr. Strickland, Mr. Kenny?
Nope.
We'll do a declaration on the sign, on the banner signs.
Yeah.
And then we'll do the other one for the sign maintenance. So if someone wants to do that?
All right. Regarding the banner signs on this violation, I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
All opposed? All right, that motion carries.
All right. Regarding the permanent sign on this case, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second it.
All in favor?
Aye.
Motion carries. Second.
I move to enter an order requiring the respondent to correct the violations on or before February 28th. If the respondent does not comply with that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
All opposed? All right, that motion carries. All right, next case is 3.14 on our agenda, case 08-26. Fine respondents Nicoletta Pasaltis, Y Building 642 LLC, and Anastasius Anastopoulos at 636 South Gulfview Boulevard in violation of code for sidewalk signs and signage without permits, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Will you come forward, sir? To the podium, sir, yes. If you would you state your name and address?
I'm
to
sorry, I
our
got a long
clerk?
name. I'm the last one, Anastasios Anasopoulos, and it's 246 Bayside Drive, Clearwater, Florida, 33767.
I'm sorry if I chopped up your name.
Yeah, no, it's a long name, don't worry about it.
Mr. Anastopoulos, do you admit or deny the violation?
Yeah, I'm a landlord, but yeah, my tenant has those signs, yes.
You admit it then?
Yeah.
Okay, if you'll have a seat right there. Can I get a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? All right, first motion carries. Inspector Burkhart, you have the floor.
All right, Stephen Burkhardt, sign inspector for the city of Clearwater. This case 08-26 for 636 Gulfview Boulevard. There are two violations. First violation is regarding code section 3-1806A, temporary sign criteria and limitations. Second violation is regarding code section 4-1002, signage without permits. And so there was one sidewalk sign erected. That's code section 3-1804J. The sidewalk sign had no permit. That's the violation. As of today, the sidewalk sign is not there anymore. I took out a picture, so it's just a declaration of violation for that one. The notice of violation been mailed in July 2nd, 25. There was no certified mail, so I posted the property on August 13 last year. Compliance date was September 12, 25. So that's the violation regarding the second violation, the banner signs. There are 3 banner signs at the building for more than 30 days. As you see here, homemade Italian ice cream, gelato coffee, and that's of May. Banner signs are still there. That was the sidewalk sign. Meanwhile, it's been removed. That was December. That was today. The signs are all still there. I spoke with the tenant, and he said that goes back a while actually. Before even I start the case, I started to talk with him about the signage. He said he wants to erect permanent signage, but that costs money, and so I was giving him more time. And at one point, I opened the case because I understand that permanent signage is more expensive than the banners, but still want to be in compliance with the code. Again, the sidewalk sign is not there anymore. That picture was taken today. Compliance for the sidewalk sign can be met by removing the sign or obtain a permit, but I'm asking for a declaration of violation. Compliance for the banner sign can be met by removing the banners and refrain from re-erecting one until all the criteria and limitations can be abided by.
All right. Do you have any questions for Mr. Burkhardt? No? All right. Mr. Anastopoulos, if you want to come back up. It's just a second. So,
Yes.
what do we got going on here?
I just thought about, I got a certified letter last month, so I was kind of unaware of it, and I spoke with my tenant this week, had him remove the sidewalk sign. I wasn't aware of the multiple sign violation. If you could explain to me what he's allowed, and is it one sign's allowed, is it all 3 signs are allowed? I'm not sure on that, so I could tell him what he has to do, what he has to remove.
I would refer that to Inspector Burkhardt.
I'll talk to the tenant, make sure he comes in compliance. I wasn't aware of it, so.
From a previous case that we had today about a banner sign, I believe it was 30 days and then you have to take it down, and that's one time a year you can do that.
Okay.
But other than that, you would have to speak with
Okay.
him. So,
I'll make sure it comes in compliance.
everything will be, you can have everything done by the 28th?
Yes.
Okay, all right. Can I get a declaration for the sidewalk signs,
Yes.
and then we'll address the second part?
I move to find the respondent was in violation of the code as referred to in the affidavit in this case for the sidewalk sign. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 each day the violation continues to exist.
Second.
All in favor?
Aye.
All opposed? All right, that motion carries. And then our next one.
Okay, regarding the banner signs, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Can I have a second?
I move to enter an order requiring the respondent to correct the violations on or before January 28th. If the respondent does not comply by that date, the board may order a fine of up to $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Change that from January 28th to February 28th, sir.
Is that what I said?
Yes, sir.
I'll re-give the motion.
Just,
I move to enter an order requiring the respondent to correct the violations on or before February 28th.
thank you.
If the respondent does not comply by that date, the board may order a fine of up to of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. Thank you, sir. I was going to say he would already been in.
Thank you.
Yeah, okay, our next item is 3.15 on our agenda, which has been continued to February. So our next one is 3.16, case 10-26. Find respondents, True North Property Owner A LLC at 3404 Brigadoon Drive in violation of code for exterior surfaces, and issue an order with the compliance deadline and find if compliance is not met. Is there anyone here to speak on that? If you'll come forward, sir, to the podium. How you doing? Will you state your name and address to our clerk for the record?
It's Justin McCrillis, 4721 3rd Avenue North, St. Petersburg, 33713.
Could you repeat your last name for me?
McCrillis, McCrillis.
Thank you.
Mr. McCrillis, do you admit or deny the violation?
Admit.
You admit it? All right, if you'll have a seat there. Can I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second. All in favor?
Aye.
All opposed? First motion carries. Inspector Daniels, you have the...
Good afternoon, Board. Inspector Daniels, City of Clearwater Code Inspector. I'm bringing to you 3404 Brigadoon Drive, case number 10-26. It's one violation at this property, Code Section 3-1502.B for exterior surfaces. Notice of violation was sent out on April 16th, 2025, with a compliance date of May 21st, 2025, and certified mail was received on 4/28/25. This is what's going on at the property. The siding needs to be replaced. And that was on 4/15, that was on 12/01, and down a little lower now, you got a piece falling off now. And then this was this morning. Compliance can be met for exterior surfaces by replacing any defective structures and decorative elements of any building walls and ensure all exterior surfaces are free of mildew, rust, loose materials, and fading or peeling paint. Requesting compliance on or before March 1st, 2026. If not, a fine of $150 per day per violation if compliance is not met.
All right. Come back to this one. You think you can get this all done by the 1st of March?
Yeah, we definitely should be able to. I apologize. I don't know what happened to the letter. I found about this just recently. So I have a vendor out there. I'm gonna go out there right after I'm done. The only issue that I would see is that just if they start pulling that stuff off, if there's more on the inside, but I can keep him updated.
Yeah, I was gonna say, keep your inspector updated if you do pull some of that.
March 1st shouldn't be a problem.
Okay, all right, thank you, sir.
Yeah, thank you.
Can I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before March 1st, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, second motion carries. All right, next case is 3.17 on our agenda, case 11-26. Find respondents Hannah Bakara and Medea Ibrahim at 4004 Brigadoon Circle in violation of code for fences and walls and exterior surfaces, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that one? If you'll come forward, sir. Good afternoon. If you'll state your name and address for the record, please.
My name is Pierre Daniel. I'm here representing my dad and my mom, Hannah Bashar and Madiha Ibrahim. My address or this address? That's
your address.
7023 Mistletoe Court, Newport Richey, Florida 34553. 34653.
Do you admit or deny the violations today?
Yes.
Admit them? Yes? Okay, if you'll have a seat right over there, we'll get back to you in just a bit. Can I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries.
Good afternoon,
Inspector Daniels.
Board. Inspector Daniels, City of Clearwater Code Inspector. This is for address 4004 Brigadoon Drive, case number 11-26. There's 2 violations at this property. Code section 3-1502.b for exterior surfaces. Code section 3-808 for fence maintenance. The notice was sent out on April 18th, 2025, with a compliance date of May 21st, 2025. Certified mail was received on May 6th, 2025. There you got a little wood, little damage to the wood. Some wood was replaced, touched up, but never repainted. Got some rotting wood down here. This was the fence, but they moved the fence. They moved this piece of fence. And this is more of the fence that's broken. This was on 12/4. The wood's still missing. Part of the fence is gone, but still the rotted wood is there and starting to get a little surface mildew. The wood is still the same in the back. Fence, still the same. As of this morning, wood still missing. Rotten wood, would need to be painted, and the fence is still in the same condition. Compliance can be met for the exterior surfaces by replacing any defective structure and decorative elements of any building wall and ensure all exterior surfaces are free of mildew, rust, loose materials, and fading or peeling paint. Compliance can be met for fence maintenance by replacing any rotten or broken boards, make sure all posts or footers are solid, and make sure that the fence is in a vertical position, not sagging or leaning more than 10 degrees from vertical. We are city requesting compliance on or before March 1st, 2026, or a fine of $150 per day per violation if compliance is not met.
All right. Thank you, sir. You want to come back up, sir? Are you able to get this stuff like taken care of by March the 1st? Yeah.
I'll definitely do my best. It's just me doing everything because my dad is just, he's not doing well right now, and my mom by herself. So I would please ask for like 30 more days if that's okay for the court. But I would definitely try to do it by March 1st.
Yeah, because this is, you guys were notified back in last April.
I know my dad had a stroke in April, and it's been a tough time for us because he's been hospitalized for more than 2 months, and we were just with him doing that.
I'm sorry to hear that about your father. I hope he's doing better.
Thank you.
Board, do you have any questions for the, Reno? No?
I do not.
Do you have any, board, do we have any problem with extending it out? Does the city, do you have any problems extending it out 30 days to give them time? Board, does that sound okay?
Sure.
To you guys?
So
Okay.
instead of 3-1, it'd be 4-1?
Yeah, I'd say 4-1,
Okay.
April 1st. So, okay, we're going to extend it out till April the 1st for you, and let's try to get this stuff taken care of, okay?
Absolutely.
All
Thank
right.
you so
Your
much.
parents will love you for it.
Thank you.
Does,
Thank you so much.
okay.
Go ahead.
All right, I move to enter an order requiring the respondent to correct the violations on or before April 1st, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. All opposed? Second motion carries. All right, next case is 3.18 on our agenda, case number 12-25. Find respondents Michael Carantonis at 123 North Glenwood Avenue in violation of code for permits and issue an order for compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No? Inspector Reese, you have the floor.
Good afternoon, Code Board. I'm Inspector Kat Reese with the City of Clearwater. This is for case 12-26 at 123 Glenwood Avenue. You have one violation on this property for permits required, section 4-203.A.1. No person shall commence any construction, demolition, modification, or renovations of a building or structure without first obtaining a permit. This is specifically permit for masonry work done on the front of the property. Before I go into the whole thing, I did speak with the property owner, Michael, this morning. He is in Colton, New Hampshire. He advised me that he has worked on getting a GC hired to pull a permit. He did request a 60-day rather than a 30. I have no objection to that if you want to just see everything real quickly, but we are now in communication as of this morning. So the notice of violations were sent, first one June 27th of 2025, and the final August 7th of 2025. First, we had 3 different compliance dates, and certified mail was signed on August 20 of 2025. And this is just in reference for where the property is. It's just south of Drew Street and east of Highland Avenue. It is the corner house right there. This was a Google photo image from 2019. And this was my inspection picture, and you can see where the masonry work. It was basically AC that was removed from the wall, and they filled it in. So it's nothing too complicated. However, he does have more issues on the property, so he just wants to get it all encompassed with everything at once, which is why he was requesting more time. And compliance can be met by obtaining an issued permit and completing the permit 6 months from issuance. So originally I was recommending, I did change it, I'm sorry, excuse me. So I'm recommending to be in agreement with him that a permit is obtained by March 28th of 2026 and completion of a permit 6 months from the issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Did you want another 30 days out from this March 28th?
No, I've already, yeah,
okay,
that's the
it,
agreed.
okay.
Yes, originally I would have done naturally 30 days, but.
And you're in contact with him, so
Yes.
everything's going to start flowing?
Hopefully, but
Hopefully.
in case it doesn't, that's why I still wanted to present it.
Okay. Can I get a first motion?
Move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Can I have a second motion?
I move to enter an order requiring the respondent to correct the violations on or before March 28th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
Aye.
All opposed? All right, second motion carries. 3.19 on our agenda is continued until April 22nd. 3.20 is also continued to March 25th. The next up is 3.21 on our agenda, case 15-26. Find respondents, Wesson Road Investments, Columbus LLC at 705 Vine Avenue in violation for code permits and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No? Inspector Reese, you have the floor.
Hello again, Code Board. Inspector Kat Reese for the City of Clearwater. This is for 705 Vine Avenue, case number 15-26. We have one violation here for permits required, specifically a permit for the interior remodel, which was to include plumbing on the property. The first notice of violation was sent April 16th of 2025 and the final on May 30th of 2025. first compliance date was May 6th of 2025 with the final of June 20th of 2025. Certified mail was signed on April 21st, 2025. I also went on this property when the contractors were on site, so I did issue a stop work order on the property. Okay, so in reference to location, this is going to be just east of North Myrtle Avenue, south of Seminole Street. And that was my stop work order that was given to the contractor on site. This is what the property looked like when I approached the property. So clearly, there's a lot of work going on inside.
It's a neon sign.
So it's a lot of drywall, you know, it's not too much. I know it looks like a lot more than it really is, but mainly it was the drywall and the bathroom that's being done, and new plumbing connections in the bathroom, so that is why the plumbing will be required as well. Drywall all the way up to the ceiling. And new framing on the doors there. So compliance can be met by obtaining an issued permit and completing said permit 6 months from issuance date. I have not had any communication from the property owner. Well, in June 18th of 2025, I did speak with a Randall who was not happy to speak with me. He disconnected our phone call, and I have not heard from him since, so I don't foresee.
I'm actually surprised they let you in to take pictures.
Yeah, he did. Most of the time
That's what I was
contractors
like,
are not,
where's the
they're
permit?
not
No.
wanting to put up a fight. And I understand that they're just doing a job, and they, you know, they know that's what they're there
It
to.
was real
for.
surprising to see
Mhm.
pictures, you know?
And they know better.
So I am requesting compliance by obtaining a permit on or before February 28th, 2026, and completion of permit 6 months from the issuance date of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
All right. Do you have any questions, board? No? Can I get a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Can I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before February 28th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Aye.
All opposed? Second motion carries. All right, next case is 3-22 on our agenda, case 16-26, find respondents Anita Desjardins at 1387 Mission Hills Boulevard, Unit 39B, in violation of code for permits and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Ma'am, would you come forward to the podium, please?
If we could just have a correction, the violation is actually a housing violation, not for permits. I'm not sure, yeah.
Okay. Can you state your name and address for the record, please?
Anita Desjardins, 1387. Mission Hills Boulevard, Clearwater.
Mrs. Jarnes, do you admit or deny the violation? You admit it? Okay, if you'll have a seat right there, we'll hear from the city and then we'll get back to you.
Okay.
Thank you so much. Inspector Reese, you have the floor.
Hello again, Board. This is Inspector Kat Reese, code case number 16-26. This is for 1387 Mission Hills Boulevard, Unit 39B as in Bravo. We have one violation here. It is a housing violation under the International Property Maintenance Code, Section 702.1. A safe, continuous path of travel shall be provided from any point in a building or structure to the public way. We have the first notice of violation that was given from our previous inspector on July 29th of 2024. My final notice was sent July 31st of 2025. She has had multiple compliance dates. These are just the ones that are matching with the notice of violations. certified mail was signed on August 8th of 2024. So this is going to be condos that are south of 590, right where Johnny's Italian restaurant is, just to give you reference. Straight down is the whole neighborhood there. This is the approach to to Miss Anita's condo. Just to give you more reference, this is her front door. So this came in from the previous inspector, who did go out there with police and a bunch of different entities to try to assist Miss Anita. It was in reference to emergency services that could not really gain access to her home. So that is that was the state on the initial inspection of what it appeared. That is the front door. It does not swing open all the way, which is why we are here today. So I will breeze through these quickly to just, afford her to not have her whole place shown. But compliance can be met by generating a safe, continuous path of travel to be provided from any point in the building or structure to the public way. So more specifically, the front door, because it opens inward, that has to have a clear opening. That is what we are focused on here today. There are other cases with the HOA that are being taken to court for the remainder of it. So, that's probably why you had permits, Nicole. It's my fault, I am sorry. So this is in reference to the housing violation for a means of egress. We're requesting compliance by generating a clear path of egress and/or travel on or before February 27th, 2026, and a reinspection with myself be completed on or before February 27th, 2026. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Okay. Board, do you have any questions?
Yes. Sounds like I don't know if it's your only concern, but your main concern for compliance is that the front door open fully.
Right.
Anything else is beyond that, is that correct?
Correct.
Okay, thank you.
Mr. Jonas, would you like to come back up, please? Hello, you think you can get your front door and everything all cleaned out, hon?
Everything, I'll get everything.
That's, if a fire would break out, hon, you'd be,
I know, I ain't got depressed.
I understand, that happens, I completely get it, and we're not here to try to shame you or anything like that, we just want you to be safe, and you'll get that all cleaned out for us?
I will.
All right, for you too, we don't want to
I
see
know.
anything happen to you, all right?
Thank you.
Okay, thank you so much. Can I get a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries, and you keep in contact with her, and
I will.
she'll take care of you. Thank you so much today.
Have a second.
I just wanted to address her so she can go ahead and sit down.
Try to
All right,
step
can I
on
have a
this.
second, please?
I move to enter an order requiring the respondent to correct the violations on or before February 27th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. All right, our next case, 3.23, has been withdrawn. 3.24 on our agenda, case number 18-26, fine respondents Wolf Empire LLC at 1738 North Fort Harrison Avenue in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on that? Would you come forward, sir? Did I say the wrong?
No,
Oh.
I tried to confirm if this was his.
Will you state your name and
property.
address for the record,
Alan
please?
Blythe, 821 Riverview Lane, Tarpon Springs.
Mr. Blythe, do you admit?
Blythe, B-L-Y-T-H-E.
Mr. Blythe, do you admit or deny the violations today?
I don't know what the violations are.
Okay, that would be a denial.
So
That would be a denial?
I deny it.
Okay, well, have a seat right there, and the city's gonna present their, what they have, and then we'll call you back up, okay, sir? All right, Inspector Reese, you have the floor.
Okay, I'm Inspector Kat Reese with the City of Clearwater. This is for case 18-26 at 1738 North Fort Harrison Avenue. We have one violation here for permits required, specifically for the interior remodel done on the property. We had 3 notice of violations that were sent, March 18th, 2025 being the first, the final on April 30th of 2025, 3 separate compliance dates. I did have certified mail signed on March 27th of 2025. And I'm sure you all know where North Fort Harrison is, but there you go. So just to give, I did pull up a Zillow posting of what the property used to look like inside. As you can see from the entrance, it does have drop ceilings, a wall here with the windows, more drop ceilings throughout the entire property. Just to give you, we're more focused on the front of the property, which would be this area here and throughout this area here. And then, so to go back to my slide, okay. So as of today, there is no permit on file. I just wanted to give reference for that. This is the property upon my inspection. As you can see that there's a truss there. There's no more drop ceilings. There's electric that's been added to the ceiling. There's been no permits for any of this work. And that's just more pictures. It's very difficult with the reflection, so I apologize for that. Compliance can be met by obtaining an issued permit and completing said permit. The city is requesting compliance by obtaining a permit on or before February 28, 2026, and the completion of said permit 6 months from issuance of the permit.
Now, did you have to do a stop work order on this one too also?
No, I did not, because the work was already done, so I just went ahead and sent the notice of violations out. For this property, I have been in contact with him, but not in reference to this particular property. And the LLC is not under the same name as this other property, so that's why I asked him today, but I got the numerics wrong when I asked him, so that's why he didn't confirm at that time.
Okay. Mr. Blythe, would you come back up, sir? Looks like they got some work with no permits.
Okay, I purchased the property. The only thing we have done to the property is scrape the windows clean, paint the inside, and clean up the outside and paint the outside. We I've done, whenever I spoke to the city, whenever I guess this first came up, I thought they had just said, okay, because I didn't do anything to the building. When I bought it, it was like this.
Yeah.
When did you purchase it?
Yeah, when did you purchase it? What date?
2023, 2024, somewhere around there. I don't know exactly. We purchased it because we owned the property adjacent to it, and it came up for sale, and I purchased it. And that's the property. It had tenants in it. It had people living there whenever I purchased it. And of course, wasn't zoned residential, so I got rid of them. But other than that, all I've done is scrape the windows clean, cleaned up the property. It had it looked really bad outside, so we fixed it up and painted it. And I didn't think I needed a permit to paint and clean up the property and scrape windows.
Inspector Reese, do you know when those pictures were taken on Zillow? Does it have a date of anything? Because this is going to be really hard to, say those were after 2023.
Well, much like any violation in reference to permits, violations do not go with the property owner, it goes with the property. So even if he did buy the property and it was not permitted and we do come into light of the said violation, he is ultimately responsible for that. But to answer your question, this Zillow posting was, let's see if we can find it.
I was just curious to, not saying that you
not telling the truth, but I'm just curious to try to.
I'm not positive 100% on when I purchased it.
I'm just trying to figure out the timeline, you know? But like she said, it doesn't matter anyways, the violation is with the property, not with the purchaser.
They're welcome to come.
There's a date,
Yeah.
2015.
It looks like it would have been
Price
that
history.
date for the price history, correct?
15,
Yeah.
so, yeah, it very well could have all been done.
Well,
before
those are sale dates though, so I don't know if those,
Right.
those apply to the pictures.
Again, there were people living here. They had a lease, and there were people living. Of course, it's not zone residential, it was by no way in compliance to be a residential dwelling, and it's been vacant ever since I purchased it.
Did you have a title search, sir, when you purchased?
Yes.
And the fines didn't come up from the city?
Are there? I don't think there is fines yet on this place, is there?
Right.
Yeah, we haven't
We
made a
wouldn't
rule.
have had that if the purchase, we're just now bringing the case, so
Okay.
So they
we just
wouldn't
now
have-
became aware of it. We do normally
Do we have any?
consider this to be kind of a private issue when sellers, as you know, when sellers sell property, there's disclosures that they're supposed to make. And so if they did work without a permit or something like that, then they're supposed to disclose that to their buyers. If they fail to do that, that's really a civil matter between those two parties. From the city's perspective, we just need to make sure that the work is safe and code compliant. I can't really speak for the building department exactly in terms of what they would want to see here, but I'm sure, since the work's already completed, if we could, if a contractor can, give us an affidavit or something like that, just to say that it's up to code, then it should be pretty straightforward getting the permit. I don't want to speak to it too much, but.
I just hate to, have Mr. Blythe here, him hung out to dry over somebody, something that he didn't do, so that's right. Is there, Dana, could you come up, sir? We can ask you a couple questions. Just so we can figure out what, like, the building inspector. Can you give us some insight on this, or like some, like, guidance on this property, on what he would need as far as, what the building, like Counselor said, what the, contractor, can he come in and inspect it and sign off on it? And so how would this work?
Well, it would, it seems to be a simple, I guess, a demo permit where the ceiling was taken out. Probably electrical was capped off. Looks like there was some drywall work that was done that, on some framing that was, we'll call in the possible attic space where that vaulted ceiling is. So it would pretty much be a electrical final, building final. We'd have to verify the screw pattern of the drywall. Possible wall taken down.
See, that's what I'm trying not to, I mean, this is a tough one.
Well, it's a.
Because I don't think that he should be,
Right. Well, it is a.
liable for all this. I mean, if there was no disclosure
Right.
to
Right.
him at, how's he supposed to know?
Well, he may have a
I mean,
cost.
that's why I'm trying to find a middle ground here.
Right.
That's why I brought you up, Dana, to see if there was some sort of,
Well, the data that I see is that the violation goes with the property, not necessarily the owner.
Right,
So
yeah,
if he
right.
purchased a property, wasn't disclosed, then maybe he's got some sort of cause of action against the seller. That's in their world.
Yeah.
But it would seem if the work was unpermitted and a permit is required, then somebody's got to go in and, somebody qualified to go in and look at it, figure out what was done, pull a permit, get the inspection, sign it off, and that, Dana, correct me if I'm wrong, Kat, but if that would seem to be a typical course of action.
Yes, it is going to be an after-the-fact permit regardless. Just to keep in mind, most of the work I'm going to bring here, people, for example, next month, all of Brigadoon, these residents with their patio enclosures that were built 20 years ago, so everyone's going to have that same story. So whatever decision you make, I'm just going to suggest to keep it, clear across the board for everybody, because that's going to be most of my cases coming forward. And I do have 2 more cases for Mr. Blight's two separate other properties that are here today to be met as well, for also work done without a permit.
Well, we'll just kind of address them one at a time, and I want to be clear that he may have remedies, as you were saying. I mean, we can't give him legal advice on what to pursue, but just because someone buys something and it's not exactly what they thought, there's real estate agents involved in that. There's title companies. There's those are professionals that have professional standards where there's potential remedies available there. Obviously the seller has certain duties and to disclose things. So if this situation ends up in being a significant financial burden for him, I would encourage you to talk to a lawyer and consult them with what your options are. From the city's perspective, it's pretty cut and dry. There's work done. If people could simply sell the property and then escape liability like that, then it would encourage people to kind of do some shell game transfers and avoid permitting requirements. So that's why we try to be as fair and as reasonable with people as we can, understanding that they may have just bought a problem that they didn't know about. And the way that we can do that is usually we can give them more time to sort it out. With the after-the-fact permits, sometimes we'll look at letters from private contractors. If an engineer puts a seal on a letter and says it complies with the building code, or the building official has discretion to accept documentation like that. But at the end of the day, that's kind of all we're looking for, is that code compliance element.
And I'm just curious, how did this come up now?
This was reported from one of the general code officers. So they typically, if they see something was done, they will report it to me. That is their specific area. I cover half of Clearwater by myself, so they're just more aware of what's going on in their area, so that they give me those violations.
Okay, thanks. 2 years later.
So board, do we have any recommendations on this? I mean, Mr. Blythe, it's pretty cut and dry. I mean, it's like council said, that either you're gonna have to go back and, civilly or something maybe with the people you bought it off of for non-disclosure of all this, but it's basically, our hands are tied as far as.
So the remedy is what?
Remedy would be maybe to call in, like council said, a general contractor or an engineer and get them to stamp off on it, and then bring it to Dana at the building department and say, here, and see if he accepts that, or,
Let Dana.
Dana, I'm sorry.
The process would be the same as if the work was not done.
Just
You have to get a contractor, you have to apply for a permit, you have to get the permit issued, and inspections must pass.
Yeah.
So architect may be able to sign off on it. The city would be open to more time if the board would like, because it appears that the property owner didn't know that the work was actually done.
Yeah, I mean, even by the Zillow and his recollection of when he bought it, I mean, it kind of says that he didn't have any idea. So, what was your recommendations on this?
I requested a compliance date of February 28th, 2026. We could keep it at that, and like Mr. Simpson advised before, my biggest thing is if you stay in communication with me, I'm always going to work with you. Once that communication stops, I cannot be an acting property manager for all my cases. That I just move on with my process, and I'd like that to continue. If he keeps in contact with me, I see there's progress being made to obtain a permit, I have no problem not filing the non-compliance affidavit.
Well, this is under LLC. I've been in contact with her on another matter on the adjacent property. And I was in compliance, I thought. I came and submitted plans to the city and waited for about a month, didn't hear anything, so went back and they said these plans
I just want
I
to
just want
state
her
to
to know,
this property, that will be, that will be up next.
I would never dodge her.
No, we're not saying
avoid her,
that.
whatever. I didn't get any notice on this. I thought when I went down.
Sir.
You gotta speak in the mic.
When I went back downtown to talk about this, I said, look, I painted the place and scraped the windows. That's pretty much the extent of what I've done there. I, you know, cleaned up the exterior and, it's got an easement through it. I put pylons back out. They were there before, but they were knocked down. They've been knocked down 3 times since I've owned the property, just from traffic going through there. So, you know, I wouldn't try to avoid her or dodge y'all or do anything to.
We're just
to
trying to
not be in
figure out a way
compliance.
through, that's, you know, the least destructive for you as far as, you know, and I don't think there's, I don't, just like our building code guy said that, you know, it's just gonna have to go through the process, I guess. So,
Sure.
you know,
Well, on a separate matter, it took me a really long time to find an engineer who was willing to take on the little project that I had to do for this other thing.
maybe you can get him to
I'll
come over.
I'll get him on it. I mean,
Come over to this.
he knows somebody who can help me as far as the contractor goes.
Okay.
He's, the engineer that I hired was, you know, he was covered up with everything that's happened here in the past, you know, couple of years. So.
Okay, all right, well, we're gonna go ahead and rule on this case then, but, you know, so like I said, our hands are gonna be tied on this one.
Take a turn.
Okay.
So, First, can I get a first motion on this, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion passes. Can I have a second motion?
I move to enter an order requiring the respondent to correct the violations on or before February 28th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Keep in contact with Mr. Blythe, keep in contact with her, and, you know, she holds the key to, you know, keeping you out of here. So, all right, our next item is 3.25 has been withdrawn. Our next case is 3.26, find respondents Troy Allen and Mary Blythe at 413 Pleasant Street in violation of code for permits and issue an order with compliance deadline and fine if compliance is not met. Mr. Blythe, would you approach the podium, please? Do you admit or deny these violations, sir?
I admit this violation.
You admit these?
At 413 Pleasant Street.
Can I get a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? First motion carries. Inspector Reese, you have.
Hello, Code Board, this is Kat Reese, Inspector for the City of Clearwater for case number 20-26 at 413 Pleasant Street. This is for one violation for permits required, specifically for the front deck that was constructed on the property. We have the first notice of violation was sent out March 12th of 2025 and the final on August 1st of 2025 with 3 separate compliance dates, 2 certified mail return receipts, first on March 3rd, March 27th, 2025 and August 12th of 2025. This is going to be adjacent to the property that we just covered. And this is the property, this is a Google image on March 20th, 23, and that was the front porch at the time. And this is the front porch as it currently stands now. I did speak with Mr. Blythe in reference to this property, and he advised me that he was having a hard time getting an engineer to sign off on this, that it more than likely would have to be removed. And then I had personally not heard from Mr. Blythe after that second conversation that we had had. So I did go ahead and move forward with my case, and then I was speaking through the ring for the notice of hearing that I placed, and him and I had a conversation via the ring. And he advised me he was having a hard time with getting an engineer. He has since done so. There is a permit that was pulled. However, it's still in review. And just before Code Board, I did speak with a planning, and there is going to be a zoning issue here. So it is going to take a little more work for Mr. Blight to get this permitted, to get an active permit, because it is a non-conforming property. So I did suggest that he come over to our building to meet with planning and zoning to see about getting an FLD submitted. But again, just like the other one, I would like to keep the compliance date the same, and I will work with Mr. Blythe as long as communication is open. So
Excuse me.
compliant. Oh, go
Excuse
ahead.
me, getting a what issued, FLD?
FLD, yes.
What is that?
It's, I don't want to speak too much on it for planning, but it is basically a flexibility
Okay.
to allow
Okay.
him to keep the porch, because it has expanded, which then takes it out of the nonconformity, so.
Sorry, just didn't know what that was.
Yes.
Okay.
Any board, any questions for Inspector Reese?
No, might have one for the owner.
Okay, so then I will be asking for a compliance date to obtain a permit on or before February 28, 2026, and completion of permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist. And again, I will work with them if communication stays open.
And you said he has the permit, it's been filed, right?
It has been filed, so he
Okay.
just
It's
has
still
to
under
come back.
review.
Right.
Okay, all right.
No, I'm
Mr.
good.
You're good?
Yep.
Mr. Blythe, could you come up? So, the 28th, and then after that, 6 months for the permit, is it, yeah, that's good, yeah? Okay, all right, that's all we want. Thank you, sir. Can I get a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before February 28th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. All right, next case is 3.27 on our agenda has been withdrawn. And I believe that is all of the new business cases. And now we will go to old business items. Accept the affidavits of compliance listed for 4.1.1, 4.1.2, 4.1.3, 4.1.4, 4.1.5, 4.1.6, 4.1.7. Can I get an affidavit?
I move to accept the affidavits of compliance as listed.
Second.
All in favor?
Aye.
All opposed? All right, motion carries. Next is 4.2 on our agenda, case 93-25. Accept the affidavit of noncompliance for respondent Juan Ariel Silva at 904 Vine Avenue for residential rental business tax receipt. Is there anyone here to speak on that? Inspector Dixon.
Good afternoon, Board. Sarah Green, Interim Code Manager. They have not applied for or obtained a BTR as of this morning.
Okay.
I'm sorry, they have not what?
Have a
for the
business
haven't
tax
applied
receipt.
for it. Okay,
So
thank you.
let's find him, so let's go
Okay.
ahead.
You ready?
Yep.
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, motion carries. Next is 4.3 on our agenda, case 115-28. Accept the affidavit of noncompliance for respondents Mary and George Ackerman at 832 Narcissus Avenue for fences and walls.
Mr. Chair, all of the affidavits, they are sworn statements that the properties are in violation. So unless there's someone from the other side here to object, I think you can just accept the affidavit.
All right.
I mean, unless you want to hear from the inspector.
I don't know. I always did this because I know these guys like to sit out and hang out for a little longer.
Okay.
Oh, you guys.
They're welcome to come.
We're
up
doing
and
this for you guys, you know, so let's go back to the office. But yeah, no, that's all right.
Okay.
That's fine.
So, yeah, let me get can I get a motion?
Somebody else read.
That's non-compliance, right?
Yes.
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, motion carries. Next case, 4.4 on our agenda, case 122-25, accept the affidavits of noncompliance for respondent William Joseph Reese at 1390 South Hillcrest Avenue for residential rental business tax receipt. Is there anyone here to speak on that? No? Can I have a,
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
all in favor?
Aye.
All opposed? Motion carries. Next is 4.5 on our agenda, case 128-25, accept the affidavit of noncompliance for respondents Caroli Windows and Doors LLC at 1165 Eldridge Street for permits. Is there anyone here to speak on that? Yes. Will you come to the podium, sir, and state your name and address to the clerk for our records?
My name is Clint Morrell. I'm an attorney with Becker and Poliakoff. Our mailing address, new to the firm, so I'm going to have to read it off of this card, is 1511 Northwest Shore Boulevard, Suite 1000. That's over in Tampa, zip code 33607.
So we are here for a noncompliance for Caroli Windows and Doors LLC. Are they refuting this, or?
No, we're not refuting that we haven't obtained a permit in accordance with the prior order. I'm here to explain what's happened since then.
We'll hear from the state, or from the city first, and then we'll come back to you.
Hello, I'm Inspector Kat Reese with the City of Clearwater. This is going to be for 1165 Eldridge Street. Let me go ahead and pull that up for you. Just to give you, I'll run through the pictures to give you some memory of what this was. This was the fence that was brought before the board and the changes that were made there. I have gone there a few times to see if there was any progress, and there has been no progress or communication. This is as of today. There has been no change to any of the fences on any side.
All right. Okay. Sir, go ahead.
Thank you very much. So Caroli, after the prior hearing, there was an incident where this gate sustained damage from a vendor that was on property. Apparently there was a back and forth. They've now been in agreement to pay it. I think it's been repaired. The company thought that when it retained the contractor to repair the gate, that contractor would be willing to submit for the after-the-fact permit for the fence. Apparently those contractors balked, did not want to do that. Caroli, its principals decided that they would apply for the permit themselves. I actually spoke with Ms. Reese earlier, and she advised me that that's not possible because it's a commercial property. So I relayed that information as I've been sitting here to my clients, and they've indicated that they've set up some more meetings with additional contractors to try and submit for the permit. So we acknowledge that it's not happened timely. I apologize for that. We're here to request leniency and some additional time to bring it into compliance. I don't think it's been alleged that there's a safety issue, and the compliance deadline, I believe, is in April, so hopefully it's still something that's feasible. So we would request some additional time to be able to apply for the permit. Thank you.
We've already ruled on this, correct? I mean, in a previous.
Yes, I mean, this here this is my position. I, on behalf of the city staff, you may want to consult the board council as well, but in my view, the question is whether or not they were in compliance on the deadline that was already imposed. Now, we have had cases where accepting that non-compliance affidavit was postponed, but that would not affect the order that's already in place. So if it came back next month and it was still in violation and you accepted it at that time, the fines would go back to the original order. I mean, I'll defer
Because
to
we already
your-
found this in violation in this case.
Yes,
Yeah.
from a procedural standpoint, yes. And then in terms of whether or not you have other options, I would defer to your attorney to explain those to you.
I mean, I think I agree.
Yeah.
At this point, it's accepting or not accepting the affidavit
Yeah.
of noncompliance. If you subsequently accept it, the fine runs from the date of noncompliance.
Yeah.
So, I mean, that's up to the board.
And then
otherwise.
it's 3 months after the order's signed.
Right.
Correct? Not from that original.
It's from when the date of you accept the noncompliance.
Okay. So there's going to be 3 months there before anything really kicks in, so. Correct?
No. It's from, if you accept it today, then it's from the date that you've accepted the noncompliance. It would be today.
Yeah.
Yeah.
Yeah, that's what he said.
That's what you said.
Yeah.
Okay,
Okay.
so that gives you till April.
Yeah.
Right,
So-
January, February, March, April.
Somebody read.
Okay. I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Aye. All opposed? Okay. Thank you, sir.
We're going to get a copy of that order?
Yes.
Next is a nuisance abatement lien filing. 6.1 has been withdrawn. 6.2 on our agenda, case number 35-26, acceptance of nuisance abatement lien for respondents Good Shepherd Boulevard LLC at 1746 Drew Street for inoperative vehicle, and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Caspin, you have the floor.
Okay. Give it a second. All right. Good afternoon again, Board. Daniel Kasdan, Code Enforcement Inspector for the City of Clearwater. This is case number 35-26 for 1746 Drew Street. This is a nuisance abatement, but there might be a bit of a change at the end. We'll go through it there. There's one violation for Code Section 3-1503B6 for an operative vehicle. This is the dates the notice of violation was sent with the compliance date and the affidavit of posting. This is 1746 Drew Street. It's brought to my attention by a fellow inspector. This is a little mini shopping mall of 3 storefronts. This little food trailer was part of the issue. We'll see more photos of it. It still is considered a vehicle. It has no license plate on it, but it is also hardwired into the ground. It has plumbing into the ground and it has electric into the ground. So, you'll see later on what we're going to ask for while we're asking for it. Can't exactly tow it in that state. But on the rear of the property, you see a white pickup truck there, and behind it is a big black box truck. The back of the pickup truck is full of motorcycles and four-wheelers and bicycles. Again, not really towable in that state, has no license plate on it. In addition, the box truck at the time didn't have a current tag, but also something that we're not really able to tow, and it was full of materials, and a little bit beyond what we usually deal with. I did post the property after sending a courtesy letter, trying to get in touch with the owner. Nobody called me back. That day, the white truck was in the same state, the black truck still had an expired tag, and the trailer still had no license plate on it. I went back after compliance date. This vehicle had no license plate on it still. The truck had no license plate, but the black box truck did have a current tag on it now, so that one's better. This was this morning. This vehicle still has no license plate on it. It's still hardwired into the ground, both plumbing and electric. And the white pickup truck still has a bunch of motorcycles, four-wheelers on it, and still has no license plate, so.
I mean, the big truck was gone, though.
No, the back truck actually is just backed up to it's still there, it's taken care of. They have another box truck there that has slowly got tires deflating, so it's probably gonna end up being operative soon. But same issue we're running into, being a bit beyond our normal towing capabilities. So compliance may be met for an operative vehicle by displaying a license plate with current tag on every vehicle / ensuring that all vehicles are physically operable, or by removing inoperative vehicles from the premises. And I'm requesting compliance on or before February 14th, 2026, or a fine of $150 per day per violation for each day the violation continues to exist.
And I have a question. What about the fact that it's hardwired in and hooked to plumbing?
That's why we're kind of asking for liens in this case, because I don't have the ability to really tow anything off that property.
Right.
And if anybody's got any questions about that, I'll defer to management or Jared.
Well, wouldn't they have to get a permit for that, though?
Good afternoon, Board. Sarah Green, Interim Code Manager. Those cases will be forthcoming in the future. This is just a
Okay.
P&U that could be brought sooner.
You found that afterwards, yeah, okay.
Yeah.
Yep. I don't have any questions. I know that food truck's not.
I really want to cause bigger trouble trying to yank that thing or trying to do some amateur electric or plumbing work. Considering that stuff hasn't been permitted, I really want to put hands on it.
Are they?
Yeah, really.
Just sort of off the subject a little bit for just a second. Yeah, well, I've noticed so many food trucks nowadays since like the pandemic. Have the city like taken into consideration any more or any new laws or ordinances regarding all the trucks that have popped up?
Food trucks are a little bit of a sticky situation. They are preemptively enforced by the state statute, so we cannot do any ordinances that would preclude what the state says.
Yeah,
So we have to kind of think about what they're doing, where they're parked, how they're parked, when
I
the
just
vehicles are
wondered,
in.
since so many have been popped up over the last 2 or 3 years,
Yeah, we
see them
agree.
everywhere now. So I'm sorry for getting off the subject.
Interesting situation.
Board, do we have any questions for
No.
Inspector Cashman?
Just a comment that normally this reads 5 days. 2/14 would be 17 days from now, so a motion entering an order would be like with 17 days,
Yeah,
if that's
just change that,
agreeable.
yeah.
All right.
Yep.
Shall we?
Shall we?
All right. I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 17 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate, maintain the nuisance, and charge the respondent with reasonable cost which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
Excuse me?
Don't mean to interrupt you guys. I'm not asking to abate, I'm asking for liens on this one. I know it is a P&U, didn't want to interrupt you.
Oh,
We can amend it.
so will we just go to
This is,
affidavit of noncompliance?
No,
these
these
are
are,
nuisance-
this
this
is
is
kind of a
nuisance
new
abatement,
request they're asking as a condition. So we don't really have a set order
So,
I'm sorry?
or motion. So they're asking in lieu of
Nuisance abatement?
business abatement, a fine.
Okay.
instead of the city going out and cleaning it up, they want to start
They want a
fining
fine,
it?
yeah.
Okay. So
We just asked for your standard motions, your standard first and second
first
motions.
and second? Oh,
Yeah.
okay. All right. So that's how we're going to like handle these nuisance abatements from now on?
Well, so
No?
we've had some
No.
conversations. I mean, I think that they're, from an administrative side, with the way that our content management system is called Acela, and there's a lot of things that are sort of automated when we input data in. For these kinds of violations, they're set up as P&U cases based on the code sections, but, you know, we don't want to go abate everything all the time. It can really complicate things, and obviously people have constitutional rights and things that we have to, you know, be very aware of. And so we're asking not for the abatement here, as you saw from the circumstances. This is not something that we want to go and do that for. But we're looking at whether there's some other way that we can bring these, if we're not going to seek abatement, that we can bring them in the standard form. But here, like I said, there's they are nuisance code sections, but we're not asking for the nuisance abatement. I apologize for the confusion. We'll hopefully.
So some in
clear
this
up soon.
section will be abatements, and some of them will be possibly fines.
There could
maybe.
be some cases that we bring that we want the option of abatement, but we want the fine to run until we exercise the option of abatement. There could be some where we don't want the option of abatement at all because it's too messy or unclear. You know, there's a variety of things that we would pursue. We try to be very clear with you in terms of what we're asking for your authorization to do.
Yep, and in cases like this, we just use our first and second motions, the violations.
That's my request, unless Mr. Salzman has an objection to that.
No, I think that's the way we have to do it until it's cleared up.
Okay,
All right.
thank you. We'll work on it.
Let's have a first motion then.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Aye. All opposed? First motion carries. You have a second motion?
I move to enter an order requiring the respondent to correct the violations on or before February 14th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Second motion carries. All right, next up is 6.3 on our agenda, case 36-26, accept the nuisance abatement lien for respondents Andrew Schneidler at 2079 Loma Linda Way for lot clearing and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Cassidy, you have the floor.
This one's just gonna be a normal one, nothing new.
An abatement, yeah.
Just normal abatement.
Okay.
Normal abatement.
Thank you, board.
Well, that was the first one that we'd ever had that was a fine, or since I've been sitting here,
Yeah.
you know, in the abatement.
No,
So
those
that's
are
why
new.
I got confused when I seen your recommendation come up. Like, this
It was
is
just
usually.
about the circumstances of trying to rip something out of the ground versus
Yeah.
just a normal truck.
Yeah, I hear you.
Yeah.
I get it.
So, Danny Casman, Code Enforcement Inspector for the City of Clearwater. This is 2079 Loma Linda Way, case number 36-26. It's a nuisance abatement. One violation here for Code Section 3-1503 B7, B8, B10 for lot clearing. This is the dates the notice of violation was sent with the compliance date and the affidavit of posting. This 2079 Loma Linda Way. This came as a complaint from the Housing Association of Valencia Park. Property is not being maintained. There's trash and debris, high grass, and the pine tree or whatever that evergreen tree is out front. It's also overgrowing to the right-of-way. Needs to be lifted a little bit. And there's some cinder blocks and some other trash and debris in the yard. This was after the compliance date. Looks like somebody took the notice, but nothing's been done to the property.
We abated the notice.
And then I went down this morning, and still nothing's been done.
They took your stick this time.
Oh, yeah, I guess they did. Who knows? So, same state. So, compliance met for lot clearing by mowing the lawn and edging the curb and sidewalk, cutting back any greenery blocking the use of the sidewalk, so there's at least an 8-foot vertical clearance above the sidewalk, and requested compliance on it before 5 days from the date the board renders its order.
All right. Any questions? All right, can I get an abatement?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second?
Second.
All in favor?
Aye.
All opposed? All right, motion carries. Next
Thank you,
one.
board.
Thank you. Next is 6.4 on our agenda, case 37-26, accept the nuisance abatement lien for respondents Icon Medical, Inc. at 2451 Enterprise Road for inoperable vehicle and issue an order with a compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Daniels, you have the floor.
Good afternoon, Board. Jared Daniels, City of Clearwater Code Compliance Inspector. This is for 2451 Enterprise Road, nuisance abatement. There's one violation there for Code Section 3-1506, inoperable vehicle. The notice of violation was posted on January 7th, 2026, with a compliance date of January 12th, 2026. Certified mail was received January 16th, 2026. That's the notice that was posted. That's the vehicle. It's in a medical parking lot. It came in as a complaint. I went, knocked on the door, asked the owners, asked the employee, and the gentleman said it was his car. It was flooded in the storm, and he waiting on the insurance company. He really had no explanation why he towed it from home to the business. So there-
Probably didn't think he'd get in trouble if he brought it out of
That's
business
right.
instead of being at home. You wouldn't get him.
Yeah, so no tag on there.
It's a nice car.
It's just like my wife's.
So compliance can be met for the inoperable vehicle by registering the vehicle through the DMV and putting a valid license plate on the vehicle, making sure the vehicle is roadworthy. For the one violation, requesting compliance 5 days after the board renders its order.
All right, any questions for Inspector Dam?
No?
All right.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. All opposed? Motion carries. Thank you, Mr. Daniels. Next up is 6.5 on our agenda, case 38.26. Accept the nuisance abatement lien for respondents Todd Reese at 1104 North Garden Avenue for lot clearing and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Maddox, you have the floor.
Good afternoon, Board. Kevin Maddox for City of Clearwater Code Compliance Inspector for, I'll get it up here in just a second. Case number 38-26, 1104 North Garden Avenue nuisance abatement. One violation for code section 1503B7, B8, and B5A for overgrowth, right-of-way overgrowth, and accumulation of debris and trash. Notice of violation was mailed and posted. There was a compliance date for December 29th. Certified mail. Green card was mailed out but was not received back. Here you can see the property. Does not include this building, but it is this lot that you're looking at. It's just right on the edge of the building that doesn't belong to the lot. Grass gets very long, especially as you go further into the lot, and it just starts crawling up the sides of the neighbor's house. This is just more pictures on 12/18. On 121, I took pictures again. There was no change. Everything remained the same, still long. And then today, it was still the same, still long, still not cut. Compliance can be met, lot clearing by cutting all grass, vegetation to include the curb line, sidewalk, and continuing to maintain it, removing all trash and debris, and continuing to keep it clean. For case number 38-26, for the violations of overgrowth right-of-way and accumulation of debris, requesting compliance 5 days after the board renders its order.
Looks like at one time they pulled a tractor in there. You can see the tractor tire marks, like with a bush hog or something to like knock down it.
Up and down the garden area, there's also, many of these lot owners are becoming victims of tire dumping.
Yeah.
So there's all sorts of things going on up and
Yeah.
down that street.
All righty, can I get a nuisance abatement
I
lien?
move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. All right, 6.6 on our agenda, case number 39-26, accept the nuisance abatement lien for respondents Mark and Carol Doshier at 927 Bruce Avenue for lot clearing and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Maddox, you have the floor.
Good afternoon, Board. Kevin Maddox. This will be for, try and get this to work. 927 Bruce Avenue nuisance abatement for case number 39-26. One violation of 1503 B7, B8, and B5A, overgrowth, right-of-way overgrowth, and accumulation of debris and trash. Notice of violation was mailed out and posted on 1/16 of 26, compliance date of 1/21 of 26. The green card was mailed, but it was not received back. This is the property which has just been left to grow the way it is. I got some better pictures as you can look further into the property. This is in the front of the property here. As you're looking along the sidewalk, and the front sidewalk is completely overgrown. On January 16th, you can also see that as you go further into this property, even the trees are falling down and the grass just continues to grow higher. This was on the 21st of January, and it continued, it remained the same with no change. This was this morning with no changes and high overgrowth. Compliance can be met for lot clearing by cutting all grass and vegetation to include the curb line sidewalk and continuing to maintain it, removing all trash and debris and continuing to keep it clean. For the recommendation for case number 39-26 for overgrowth right-of-way, and accumulation of debris and trash, requesting compliance 5 days after the board renders its order.
Board, do you have any questions?
Does anyone live there?
To my knowledge, no. And the house next door and the lot across the street, it's kind of accumulation of a lot of houses that have fallen to the previous hurricane.
Right, exactly, unfortunately. I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, next up is, where are we at? 6.7, case number, 6.7 on our agenda, case number 40-26, accepted nuisance abatement lien for respondents NSB TRI LLC at 94 Devon Drive for lot clearing and issue an order with compliance deadline, authorize the city to mitigate the violation. If compliance is not met, Inspector Maddox, you have the floor.
Kevin Maddox, Code Compliance Inspector, City of Clearwater. Case number 40-26 for 94 Devon Drive. One violation for 1503 B7, B8, and B5A, overgrowth right-of-way, and accumulation of debris and trash. Notice of violation was mailed out and posted on December 15, 2025, compliance date on the 29th of December 2025. The green card was received back signed. I never heard from anyone by any other means. This is the front of the house. Over here is, I'll try and show you a different angle, but this is in a corner as you make a turn, and I don't know how this building is getting access, but it seems like all of the construction workers keep parking in front of this house and driving through the front yard to access this building over here, which apparently does not seem to have a driveway. So it's very strange. This is the front of the house a little bit closer. The height is pretty obvious. Here you can see where the front of the lawn sort of has become a driveway to this building, but but the property line comes down here, so it's very odd again. If you look back on the sides of the building, it's very long and unkept. On the 20th of January, it remained unchanged. Some of this debris is from the construction workers who just really don't care about an empty house and what's going on, so they keep staging their materials in the front because of the proximity. And then this morning, nothing has changed. The weeds are still high. Compliance can be met for lot clearing by cutting all grass and vegetation to include the curb-lined sidewalk and continuing to maintain it, removing all trash and debris, and continuing to keep it clean. For 40-26, for overgrowth right-of-way and accumulation of debris and trash, we're requesting 5 days after, compliance 5 days after the board renders its order.
Board, do you have any questions?
No. Move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, motion carries.
Thank you.
Next, thank you. Next up is 6.8 on our agenda, case 41-26, accept the nuisance abatement lien of respondents Arca Homes LLC at 1465 San Juan Court for lot clearing and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Stuth, you have the floor.
I think it's stuck.
Just thinking.
The death wheel. Wheel of death.
Only because it's the second to last one.
We run out of time, huh?
Yeah, that's right. You gotta put another quarter in. It's like the vibrating bed in old hotels, you put the quarter.
While I'm reading, have our other three members.
Okay, Vicki Sudduth, Code Compliance Inspector for the City of Clearwater. This is case number 4126 for 1465 San Juan Court. There's one violation here for overgrowth, Code Section 3-1503, B7, B8, B10, and B5A. Notice of violation was posted and mailed on December 18th of 2025 with a compliance date of 12/28/2025. It's a picture of the posting on the front door. This was the picture of the backyard on 12/18. And this is a picture of the backyard as of this morning. Compliance can be met for lot clearing by clearing all trash, debris, and overgrowth from the property. Requesting compliance 5 days after the board renders its order.
All right, any questions, board? Nope.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable cost which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. All right, next on the agenda is 6.9, case 42-26. Accept the nuisance abatement lien for respondents Christine Dorcelis at 214 South Highland Avenue for inoperative vehicle and issue an order with the compliance deadline and authorize the city to mitigate the compliance violation if compliance is not met. Inspector Seuss, you have the floor.
Vicki Sudduth, Code Inspector with the City of Clearwater. This is case 4226 for 214 South Highland. There's one violation here for an inoperable vehicle, Code Section -3-1503B6. Notice of violation was posted and mailed on 1/12/26 with a compliance date of 1/23/26. Here's a copy of the posting. It is for a boat trailer, but there is also a boat on the trailer. This is a picture of it on the 12th. That's the boat. There's the trailer with the expired tag of 5/26/2022. This is just showing you the condition of the trailer. It's breaking, the tires are flat, they've dug into the ground. And then this was this morning, the boat is still sitting there, and it still has the same tag of 5/26/2022. Compliance can be met for removing the trailer or making sure trailer has a current tag and registration along with inflated tires. Requesting compliance 5 days after the board renders its order.
Any questions, board? No?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? All right, motion carries. All right, now, board, we have to sit and elect our officers.
Yep.
So,
Yes.
do we have any suggestions? Do we have any
Yes.
Yes.
nominations?
I'd like to nominate Mr. Brown for, what's the position?
Chairman.
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 Second.
Third.
All in,
You're it.
all in favor?
And, aye.
All opposed?
And I'd like to nominate Mr. Kenny to be the deputy, or the vice, however you say it.
And I would like to nominate Mr. Engel to be vice chair.
We have a runoff.
Uh-oh.
All right, let's hear your spiels, guys. Come on. What can
I'm
you
not
do for,
angry.
what can
I'm
you
not
do for
angry.
this board?
Oh,
Can we vote?
That's the guy here, right?
Yeah,
oh, he's not,
Mr. Plum?
is he coming back?
I don't know.
Do we know anything about these people?
Well,
They knew
Daniel.
elections were today.
Was not
Daniel-
able to come. Mr. Plum did send me an email while we were in a meeting. He was not able to be here.
yeah.
Okay.
I know Daniel lost his sister, who was about 80 years old, so he's been dealing with all the family matters and stuff. I did talk to him over the weekend. Off the record, we made a little wager on a football game, just that kind of thing, and chatted a bit, and so I would assume he's fine. He had planned to be here, but I guess wasn't able to make it, so anyway.
So,
And you won't be the vice chairman if we elect you?
I didn't say that.
I'm just
I'm just
asking.
offering a second nomination. I didn't,
Oh,
I
okay.
didn't recuse or deny or say no.
Will you accept the nomination?
Yeah,
There
sure.
you go.
Of course, accept the nomination, but
Okay, we're
Up to you
done,
guys.
right? We're adjourned, right?
We just have to vote for that.
we have to vote, yeah.
all in favor of Mr. Kenny being the vice chair of the 2026 code enforcement season?
Aye.
Season.
Aye.
Aye. The ayes have it.
Okay,
So there we go.
Very
So
good.
we're all set. We have-
Excellent.
We have all the
Long
people in
meeting.
place,
Almost 3 hours.
and we're ready for, well, see, I try to keep the guys out of work. I mean, I know they gotta go back to work. Oh, wait, I'm sorry.
Thanks a lot.
And if that's, if we have nothing else, we are adjourned.
Excellent.
Thank you.
You just like.